Yes.
What about?
Yes.
May we please your lordship? My lord, I beg to mention item number 17 of today's list. My lord, kindly adjourn the matter for the day due to some personal difficulties of my senior.
19 matter, you're seeking adjournment.
17. Yes, my lord.
I don't. Matter of 19. When do you want?
Uh,
On a request made on behalf of the petitioner, matter is adjourned to be listed next week.
After 1 week, my lord.
Next week, they said.
May I please the lordship? My lord, I beg to mention item number 40, my lord, of today's list.
40.
40, my lord. This was listed, my lord, day before yesterday, my lord. And because of my lord paucity of time, could not be taken on and became a left-over item. May I request your lordship, my lord, that after completion of motion, my lord, this matter may kindly be taken up since the lady is behind the bar, my lord. She's in jail, my lord.
No, many people are behind the bars. It is not an habeas corpus which you are trying to project.
Lordship will kindly see, my lord, there are some.
No, we
materials, my
have
lord,
seen
case.
this. We do not think that this requires any out of turn treatment.
My lord, there was a bar, my lord. There was an earlier direction, my lord.
All matters are important. Had it been something extraordinary, if it reaches, we cannot assure. We cannot assure.
Another frame, my lord, item 22 and 34, my lord.
22,
And 34, my lord. I
Yes.
could not take preparation, my lord, in both the cases. That is
22 and 34, which year? 22 is of
just after a week, my lord.
and 34 is of which year? 16, 34 we are not adjourning.
Then
It
20,
may not reach, that's a
yes,
different
my lord,
matter.
that is the,
But we are not adjourning 16 matters.
my lord, then 22, my lord. Lordship.
22 will adjourn?
Yes.
On a request made on behalf of the petitioner, matter is adjourned to be listed after a week,
Right.
after 2 weeks. 26, this hearing matter may not reach, it's
Right.
up to you, but we are not adjourning.
My lord. May it please your lordship.
My lord, I beg to mention item number 6, my lord. My lord, I
Yes.
prayed for 1 week's time to file some additional document matter in this case.
What additional document in an
My lord,
FT matter?
Some exhibits are not left out. Exhibit H particularly, my lord, the other certificates, my lord.
It is there in the record.
And another, my lord, the sale deed, my lord, I have not, my
It's a
lord.
fresh matter, isn't it?
My lord,
Has it come for the first time?
first time, yes.
Then let us move it. You can file it later. Why are you seeking unnecessary adjournment? One order for calling for the records will expedite the matter.
Yes, my lord.
Be here.
May I please, your lordship? My lord, I beg to mention item number 15 of today's list.
1-5.
15.
Yes.
Lord, I have misplaced the records, my lord.
19
My-
matter, Mr.
My lord,
Priya.
my lord, at least 2
Okay,
weeks.
on a request made on behalf of the petitioner, matter is adjourned by a week. Get the records.
My lord, I will reconstruct it.
Yes.
May I please
Obliged.
praying for adjournment of item number 18 and 19, your lordship. We have some difficulties today, your lordship.
18 and 19.
Yes, your lordship.
Matters are old matters, madam. 19,
Yes,
2019, 2018 matter. You are
and
mentioning
so
on
we
behalf
have
of
some
whom?
difficulties today, your lordship. I'm appearing for on behalf of IHS AK, your lordship.
Okay, on a request made on behalf of the petitioner. Matters are adjourned to be listed after a week. Same order, which is same one order, common order. Yes.
Much okay.
My lord, I beg to mention item number 8, your lordship.
Item number
8
8, yes.
for adjournment, your lordship, on the ground that the engaged counsel is currently out of station.
Hmm?
Engaged counsel is currently out of station because of his ill health.
18 matters. Yes. Adjournment. Who's the engaged counsel?
P. Talukdar, your lordship.
P. Talukdar.
Yes.
Where is Mr. Fukan?
I have no.
Who will do the case? Who will conduct the case? P. Talukdar.
Yes, your lordship.
On a request made on behalf of the petitioner, matter is adjourned to be listed after 1 week. 8.
Right.
May it please your lordship? Your lordship, I beg to mention item number 10. I am for the petitioner, your lordship.
Yes.
Engaged counsel is not present in Guwahati, your lordship. So kindly matter may be taken off on 25th if possible.
Same order, 1 week.
Much obliged.
Yes.
May it please your lordship. Lordship, I beg to mention item number 16, lordship. Lordship, matter may be adjourned for the day. 16.
16, same 1 week. Yes.
May it please the lordship, I beg to mention for listing, for filing number 14521.
Fresh matter.
Yes, Mr. Lord.
Motion
Yes, Lord.
pertaining to this bench.
Yes.
Yes, you can have filed it.
Also, I beg to mention.
When did you file?
Okay.
When did you file?
Last week, Lord.
Last week, okay, Friday.
Also, I beg to mention WPC one for listing, my lordship.
Fresh matter,
No, hearing matter,
hearing matter, of which year?
2017.
17, okay, will come.
Deeply obliged.
Next Tuesday.
Deeply obliged.
May I please, your lordship, item number 9, lordship, after a week, lordship.
9, this,
18 matter, lordship,
no, this, have you explored the option of CA in 9, item number 9,
9,
not 7, 9. Even yes, have you explored the option of CA?
no, lordship,
You can take the option, we'll have this, we will not adjourn this matter.
lordship.
My lordship, on 25th, which is Tuesday, my lordship, I have some difficulty. I will be.
But on Wednesday?
Yes, specific is instruction.
Yes, instructions? Yes, instructions?
Lordship, may take it, I'm praying for 1 day accommodation, my lord. Can it be fixed tomorrow, my lord?
We'll have it on Friday, but he's making a very serious allegation.
Yes, yes.
That you said, written instructions that he's a foreigner detained at Matia. He said he could not be traced out in the Matia holding camp.
Yes.
Okay. On Friday.
Yes,
Okay. On the request of Sri J. Payang Leonard, Standing Council, Home Department, matter is adjourned to be listed on Friday to enable him to obtain the instructions in terms of the order dated 12/11/2025.
Previous caucus.
May I please your lordship? Lordship, this is the contested case, lordship. And 3 witnesses examined, lordship, elder brother, school teacher, and the Gangura of the said village.
Records have come. Records are with you. Yes. It is with you, G. Sharma. There is an endorsement. Let's see. If I did.
Within 10 minutes, lordship.
Okay. After a while, okay. Yes, Mr. Dean.
May I please, lordships? Please. My lord, that simple matter become very critical. Look now.
Simple matter,
Simple matter, my lord, becomes
simple?
very critical.
but how do you,
My lord, what happened in this case, my lord, this is the second round of petition, my lord, before this honorable court. Earlier, my lord, petitioner came before this honorable court challenging the ex parte order passed by the learned Borbetas 7, number 7, my lord. And that ex parte order was set aside, remanding back the, not remanding, my lord, giving liberty to the government to initiate a process against the petitioner if, my lord, question is, my lord, whether Ashok Ali is the petitioner, is the person who has given notice, or Ashok Ali. Petitioner claimed that he is Ashok Ali, but the notice was sent to in the name of Ashok Ali. So, my lord, this honorable court has set aside the ex parte order, and it was also not served to the person. It was pasted on the house, though there is a report, my lord, process server's report that there is no person in the name of Ashok Ali. And my lord, this honorable court has set aside the order, my lord, impugned ex parte order. My lord, kindly see Annexure P6.
thereafter what happened?
Thereafter, my lord, the SP filed a petition before the learned Honors Tribunal that to accord sanction to proceed against Ashok Ali. The sanction was granted, and an my committee was formed, and inspector has inquired the matter. And thereafter, my lord, he submitted a report that Ashok Ali is Ashok Ali, because some people in that locality called him Ashok Ali, but his name is Ashok Ali. So, my lord, submitted report that Ashok Ali is Ashok Ali. Accordingly, my lord, the learned Coroner's Tribunal, my lord, he has taken examine witnesses to verify whether Ashok Ali is Ashok Ali or not. Ultimately, it is held that Ashok Ali is Ashok Ali. Thereafter, my lord, set aside the order of this Honorable High Court and confirmed or restored the ex parte order passed earlier, my lord. Declare, my lord, Coroner's
Tribunal.
earlier, yes, Coroner's Tribunal. So, my lord, he has, my lord, learned tribunal has set aside this Honorable High Court's order, by which the ex parte order was set aside and restored the ex parte order passed earlier. Hence this petition, my lord. But the petitioner was not given an opportunity to file WS or documents to
Yeah,
prove his
let us see
citizenship.
the order, page.
My lord, order page
12 to 21.
46, my lord. Annexure P13, page 46, start from 46, and my lord, relevant portion, my lord, page 57, paragraph 15. Paragraph 15, my lord.
Yes, madam. Slightly peculiar circumstance.
Lordship, this small discrepancy in the name occurs most of the times, Lordship.
No, we are on the procedure adopted by the tribunal.
Yes, upholding the ex parte order.
No, could not have.
Yes.
If the tribunal thought in its wisdom that there was some misrepresentation in the High Court in the earlier proceedings,
Yes, Lordship.
the matter should have been applied, a review should be then applied for, or you file an appeal. You cannot sit over a judgment of the High Court.
Lordship may remand it back with this.
Not done like
observation,
this.
Lordship.
And it's an ex parte order.
Yes.
If you think that Ashok Ali and Ishaq Ali, Asik Ali are the same person, proceed against him in accordance with law, give him an opportunity.
The tribunal exits his jurisdiction.
And you cannot. We issue a short notice. This is an important point. We are not disposing of today itself. You not only obtain instructions, but this thing has to be clarified. Heard to the PCA Learned Counsel for the petitioner, who by means of this petition has put through challenge an order dated 4/9/2025 passed by the Coroner's Tribunal number 7th Borpeta instance, whereby
Set aside. Order was set aside.
whereby the petitioner has been declared as a foreigner post 1971. Full stop. It is the case of the petitioner that there was an earlier opinion dated 12/2/2020 passed by the Learned Tribunal, which was the subject matter of challenge in this court in WPC 608 of 2021. Full stop. This court, by the order dated 12/2/2021, had interfered with the earlier ex parte order and had remanded the matter. Full stop. However, it appears that the learned tribunal, instead of deciding the matter afresh, had examined the aspect as to whether the earlier ex parte order was justified, which clearly appears to be beyond the jurisdiction of the learned tribunal. Para, let notice be issued, returnable by 6 weeks. Union of India, anybody? B. Sharma, CCC, 1. Then Madam for Home Department, 2, 3, and 2 and 3, Madam,
Yes, Lordship.
2 and 3. Then Kotoki, Madam,
5.
and 4, P Kotoki, 4 P Kotoki, huh? And S Kotoki, 4 is P Sharma, 5 is S Kotoki, standing counsel is here. Extra copies, para, 3. They, the learned counsel, prays for an interim order, para, considering the facts and circumstances and the observations made above, comma, till the returnable date, comma, it is directed that the impugned opinion dated
4/9.
4/9/2025 shall remain suspended.
May I please, sir. This is the contested case, madam. The impugned order is page number 42. And the relevant portion is page 49. The first paragraph, my lord, page 49, my lord. May,
A Boro,
yes, my lord.
heard 3 A Boro, learned counsel for the petitioner who is aggrieved by an opinion dated 14/8/2024 passed by the learned foreigners tribunal, Chirang, in so and so case, whereby the petitioner has been declared as foreigner post 1971. Full stop. Para. Let notice be issued, returnable by 6 weeks. Um, 3, Union of India, B Sharma, 1, huh? Then Home Department, Madam B, A Verma, 2, 2, 5, and 6. Election Commissioner S Kotoki, 3, and number 4, P Sharma. Extra copies. 3. Borrow the learned counsel prays for an interim order. Full stop. The learned counsel for the respondents have, however, submitted that the approach to this court is belated. Full stop. Considering the above, while this court is not inclined to pass a blanket interim order, comma, it is directed that till the returnable date, no steps for deportation of the petitioner be taken. Full stop. The prayer for bail can be renewed after receipt of the records. Report record to call for huh? So what?
Omelette, my lord.
May it please the lordship. My lord, it is a contested case, my lord. Your lordship would be pleased to see page 61 is the impugned order.
Heard 3 MA6 learned counsel for the petitioner who is aggrieved by an order, by an opinion dated 15/3/2025 passed by so and so in so and so. That notice be issued returnable by 6 weeks. B Sharma, Union of India, 1. A Verma, Miss A Verma for 2, 3, 2, 3, and 6. Number 4 by P Sharma, State Council, and 5 by S Kotoki.
Order is of 19, Lordship, 31/10/19.
19.
Yes, Lordship. Lordship said.
Malad,
heard
I have
Lordship
explained the
24,
delay, Malad.
25, Lordship, I heard something like this.
Delay explained at page 17.
Page 61.
Was it
Lordship.
19?
Page
Yes,
14.
Lordship.
No,
I
no,
have
he's
explained the
still,
delay, Malad.
see the synopsis.
Page 14.
Synopsis, what have you stated, Mr. Sheikh? 15/3/2025.
That's wrong, Lordship. Incorrect.
Don't make this kind of mistake. Synopsis, we look into the synopsis and pass orders at the motion stage. If you make a mistake of this nature, we are not imputing anything, but this much of care you should take, Mr. Sheikh.
Malad, I'm sorry, Malad.
Some 31/10/19 has been made 15/3.
15/3.
Lordship.
How does 15/3 has any relevance with this?
Malad,
Copy paste, cut paste,
Malad, that is the problem.
copy paste.
Malad, that
Cut
is the
paste.
problem, Malad. But I may be allowed to correct this car.
No, not allowed. Cost for copy paste. How much cost? You're not allowed to do copy paste.
Generally, it is typed by the typist in a computer, Malad, this thing happened.
So he'll type whatever you say, he'll not type something from his own. Good,
I'm
yes,
sorry, Malad.
thank you, madam, for pointing out. It's 31/10/2019. Issue notice, huh, Google?
Issue of
The
maintenance.
learned counsel for the respondents. No, while the learned counsel for the petitioner has prayed for an interim order, comma, the same is strenuously opposed by the learned counsel for the respondents, who have also raised the issue of maintainability on the ground of delay and latches. Full stop, para. After considering the above, comma, while it is directed that no steps for deportation of the petitioner be taken till the returnable date, comma, the issue of maintainability raised is kept open. Extra copies, huh? Orders, records.
May I pray before your lordship that this order may not be stayed, my lord, but I may not be deported, my lord.
We have already said,
Already said.
My lord.
without your prayer, we have said.
Obliged, obliged. Regarding this, my lord, Mr.
Which one?
This index mistake, my lord.
You cannot correct it by hand now.
Synopsis, my lord.
You have to file an application. It has gone into the CIS.
Yes, my lord.
Wait, please, your lordship. My lord, the impugn order is at page 83, my lord, dated 14/11/2024.
14/11.
14/11/2024.
This date is correct in this case.
Yes, my lord. At page 183.
Now we have to verify the dates in all
Yes,
cases.
ma'am.
Mr. Sheikh has set a very bad example.
Page 83, my lord.
Heard Sri and Sarkar Learned Counsel for the petitioner who has put to challenge an opinion dated 14/11/2024 passed by the learned Foreigners Tribunal Bozali in case number so and so, whereby the petitioner has been declared a foreigner post 1971. Para, let notice be issued, returnable by 6 weeks. Sri B. Sharma, CGC 1, and Election Commission of India. H. Kuli on behalf of AI Ali, Standing Council Election Commission 2, huh? And Madam A. Verma for 3, Miss A. Verma for 3, 4, and 6 and 7.
Yes, sir.
6 and 7. P. Sharma, State Council for 5. Extra copies, call for the records of from the so-and-so tribunal. 3. Sarkar, praise for an interim order. And has submitted that the petitioner is yet to be, has not been arrested as yet. Then we'll give that paragraph, huh? That 5,000 Irish in both hands. Then after that you write, the learned counsel prays for and is given liberty to file additional affidavit.
Obliged.
bail order to the আগত দিছিলো সেইটো দি দিওঁ। Yes, Mr. Ali, what is?
My lord, impugn order is at page number 30, my lord. Order dated 23/9/2025. My lord, ex parte order. my lord. T0.
Ex parte?
My lord.
He appeared and filed also, Lordship.
But how is it an ex parte if you choose not to contest?
Yes,
What is an ex parte? Ex parte where you are not even given notice, you did not get the notice.
My lord, my lord. I
You
got
had
the notice, my
contested.
lord. I also appeared, my lord. And I prayed that another reference was decided against me. And so it may be dropped, my lord.
Those are your contention. Those have been answered.
My lord.
Heard Sri A. Ali, learned counsel for the petitioner who has put to challenge an opinion dated 23/9/2025, passed by the Foreigners Tribunal Third Dorong in FT case number so and so, whereby the petitioner has been declared a foreigner post 1971. He has contended that the aforesaid opinion is an ex parte one. Tara, let notice be issued, returnable by 6 weeks. B. Sharma, where is it? B. Sharma? This. Where is B. Sharma? Where is he? He left. Huh? If he's left, why should we record his name? We are not that benevolent and magnanimous. Leaves the courtroom like without even informing. What is this kind of conduct? Why in this matter CCC is not appearing? We have been observing. Yes, call for the Mr. R.K.D. Chaudhary. If they are not serious about this matter, we will make some observations. Put him to the gap please, so and so, huh? Yep. For one. Then the Home Department, Ms. A. Verma for 1, 2, 4, 2 and 4. Pre-Election Commission of India,
2, 4 and 6, Lordship.
6 also. Yes, 6. Election Commission of India, you'll be there. Is he there? H. Kuli, on behalf of A.I. Ali for 3. And Sri P. Sharma for 5. Extra copies, call for the records.
Lordship may even call for the records of the second proceeding, Lordship. It's at page 32, because he already has one more proceeding against him.
Call for the record.
Last paragraph, Lordship.
The age,
Page 32, in the opinion, Lordship.
the
second paragraph.
records,
FT3 case.
the records of
T3 case,
FT
27970.
3 case 2977 of 2012, decided on 17/11/2022, may also be called for, correct?
Yes, Lordship.
Sri Ali, the learned counsel, prays for an interim order, which however is resisted by the learned counsel for the respondents, who have also contended that the opinion cannot be termed as an ex parte, inasmuch as the petitioner had appeared and contested and thereafter was negligent to appear. Para, be that as it may, and by balancing the equities, it is provided that till the next date fixed, comma, it will have 8 order to bail. তার উপর ওটা লিখিবা, interim order, and by and has submitted that the petitioner has not been arrested as yet. Please call him. Why you are, okay, we'll to interact with him, no point interacting with him. RKD Chaudhary को जो है तो FTJ. Alright.
May I please, Your Honor? Sir, this is a contested matter, Your Lordship. Kindly come on page number 39, the impugn order, Your Lordship. Impugn order and opinion dated 8/8/2025, Your Lordship. Three witness has been examined, Your Lordship. Petitioner and Lord Mandal also.
Which tribunal?
My lord, tribunal number 7, Borpeta. 39 case.
Which stream? Post 71.
Yes, my lord, 71.
Your P. Roman.
I am assistant.
Yes, sir, your yes,
Yes, sir.
heard 3S Islam Learned Council for the petitioner who has put to challenge an opinion dated 8/8/2025 passed by the Learned Foreigners Tribunal 7 in case number so and so, whereby the petitioner has been declared foreigner post 1971. Para, that notice is issued, returnable by 6 weeks. 1 RKD Chaudhary 1. Yes, Mr. Sharma, where do you disappear? No. If that matter is important, be there. Don't be here. Don't give those excuses. How many CGCs are there in the court? You don't have have one CGC to attend a matter of this importance. These are motion matters. Hearing, we don't even ask anything from your assistance. If you don't even accept notice, then we'll make an observation, none from the CGC. Don't make this position embarrassing for the court. Not one CGC. B. Sharma 1. And then Miss A. Verma for 2, 4, 6, and 7. 3. Escort की standing council ECI, huh? 3, and Deputy Commissioner, District Commissioner 5 whole, P. Sharma, State Council. Extra copies, call for the records. 3. Islam, the Learned Council prays for an interim order and has submitted that the petitioner has not been arrested as yet. Full stop. Considering the above, bail to, huh? Okay.
Master President.
Record, Rahil and Gunjan.
Records have come. This we can take up for disposal.
Gunjan.
Just a minute.
Second, it was.
See, we have just thinking aloud that this is a matter of 2025. Records have come. We do not have any issue in taking up for disposal.
Yes,
But
Lordship.
there are matters of 17, 18.
Yes, Lordship. Yesterday's matter, Lordship.
Not even yesterday, there are many matters, 17, 18.
Yeah.
So I think these matters can wait for a while. New fresh matters. If we do not have any other matters, in fact, we are disposing 25 matters, fresh matters also.
Yes, Lord.
But old matters are being left out. So
Hmm.
we'll give some preference. We'll have this, it will be in admission hearing only.
Yes,
Why is it
Lordship.
for motion? More notice has not been issued.
No, Lord.
We'll issue notice, we'll have it for fair.
Yes,
Okay.
sir.
Yes,
Why notice was not issued?
Because some, there is some nomenclature is something wrong, wrongly quoted, Lordship. It is your Lordship.
You have not amended the cost title.
yes, Lordship.
Have you amended?
Yes,
Amended?
yes. I amended.
Heard.
M.A. Mondal.
Three M.A. Mondal, learned counsel for the petitioner. Full stop in this case, comma. By an order dated.
Page 83. Lordship. Page 83, Lordship.
1/8/2025. The records are called for by which order? Not order. What record here per call?
83, Lordship, please, into order.
We are not in the
83.
impugned order.
Yes.
We are on the order by which the records were called for. Records here call for 1/8/2025.
Error in the. Nice.
Records were called for by which order?
Perhaps 17/7, Lordship. 17/7/25.
No, 14/7.
14/7. Oh, yes, yes.
14/7. But why has it come for motion? I think this has escaped.
14/7.
এটা আছে ভিতৰত আছে, বেলেগ কে আছে। Separate কে আছে। Separate কে আছে। এই তো 14/7.
Perhaps due to defects in nomenclature, Lordship.
14/7.
এটা তো
Oh, it's not that.
এটা নাই নাকি কি মদত আছে অর্ডার টু
No, anyway. This
14 অর্ডার টু মদত কেনে গেছে আমার অর্ডার শিটে কিউ নাই 3133 হয় না
On 1/8 it was
communication
received.
copy है original to good good
1/8 it was received. All records were received on 1/8 by 1/8.
to 14/8 huh order क्यों नहीं ये order to কোনে মারিছে এইটো মনত কৰি থৈ দিব সেকশন ঠিক কৰি দিব মই টেলি অৰিজিনেল টু কোড গ'ল চাব লাগিব না আৰু দিব লাগিব
ইয়াতে চাওক I don't notice. Maybe what my was it? হ'ব পাৰে।
নাই নাই
ইয়াতে দেখা নাই।
14/7 নাই 14/7
এইটো 14/7 এটা বেলেগ 14/7
14/7 of order to for the case number board की लिखा है
This number is same.
This number is 3133 25 25
যে নোটিশ ইস্যু করবো বিচারিছি কিন্তু এইটো কাৰেক্ট মানে নোটিছ ইস্যু নকৰে ঠিক আছে ৰেকৰ্ডটো ডিটেক্ট কৰিছে সেই অৰ্ডাৰটো আমি চৈ নকৰিলে অৰ্ডাৰটো চৈ গৈছে না এইটো ভুল কৰিছে সেইটো ইয়াতে দিব লাগিছিল সেইখন ইয়াতে দিব লাগিছিল অৰিজিনেলটো তাতে গৈছে
আৰু তাত there's another 14/7 not ইয়াৰ পিছত
অৰিজিনেলটো চাগে ৰেকৰ্ডৰ লগত দি দিলে
সেইটো ফাইলত সেইটো
that long order is not there.
সেইটো ফাইলত গৈছে চাগে কোনোবা বেলেগ এটা ফাইলত
এনচিআৰটো থাকিলতো অৰ্ডাৰটো ৰেকৰ্ড কৰিব পৰা
which were called কি ক'লো
Received.
On it নহয় by an order dated 14/7/2025 notice was issued and the records were also called for. Full stop. Pursuant to the same, comma, the records have been received. Full stop. List the same, list this case for admission hearing after after 4 weeks. The interim order passed earlier to continue till the next date of listing.
I have returned back the LCR that may be okay.
The records of the tribunal has been returned back by Sri G. Sharma, Standing Council, Home Department, which are tagged with the court file.
All right.
It will solve over this. Not a very record to order what I order and record when I put here on.
May I please assist? Before start my learned friend Pine Miller, yesterday I left out one Jasmine Miller regarding Miller brother evidence Miller. I am relying on Jasmine Porimali Miller, 2022-3 JT 868. Para 53 Miller.
Let's dominate it.
Sorry, only one copy provided.
Salam.
Is it reported? Please give the citation. 2000?
2022 3 GLT 816.
816.
816.
Karim Ali.
Yes, Porimali. Para 53 million. Brothers evidence million.
53.
53.
Yes, please.
জেল এটা জেলটো রিপোর্ট করেন
No, there is no principle of law laid down as
Miller,
such.
what I'm saying, Miller, In the Korimalis case, my lord, DW2 is the brother, my lord. This evidence is accepted, my lord. In my case, my lord, the DW2 is the elder brother of the petitioner, my lord. That is my contention, my lord.
No, see, you place a reliance upon a case on a principle of law.
Yes.
Now, if you are relying upon 53, what has 53 said? It is also noted, Mr. Pang, in paragraph 53, it is where it is laid down as follows. It is also to be noted that the said oral testimony of so-and-so has been fully corroborated by the testimony of DW2, who was the younger brother of so-and-so, mother of the petitioner. That is not any principle of law. Have you got any decisions where it has been laid down that oral evidence in a matter of this nature can be taken into account without insisting on any documentary support?
My lord, para 51, my lord.
51, yes, please.
The evidence of the petitioner's mother, in our opinion, is highly relevant and significant, who testified from her direct knowledge about shifting the merit of to the petitioner's father and about the shifting in different villages along with her husband, and also testimony about the children born on the particulars of other relatives. Here in this case, my lord, in the Korimalis case, my lord, is the direct oral evidence of the mother, my lord. And in my case also, my DW2 is the elder brother of the petitioner, my lord. His evidence is direct oral evidence, my lord. And his name is appear along with the mother and father in 1985.
Okay, yes.
My learned friend, my lord, if anything, my lord, I may be allowed.
Yes,
to-
yes, definitely.
My lord, first of all, my lord, the issue with regard to the inquiry by the LVU, because my learned friend has argued one point, my lord, that there was no inquiry is not proper, the LVU report is not back, there is nothing in the LVU report. In fact, my lord, the law is well settled in case of, my lord, LVU reports and the devoter cases. My lord, your lordships know it well. My lord, the history of this devoter cases started in 1997. Prior to that, my lord, the IMDT was there. IMDT was enforced in 1983. Thereafter, my lord, in 1993, when the Election Commission of India directed for intensive revision of the voter list, then the voter concept came out. There are numbers of notification in that 1996, 97, 98, my lord, with that effect. And one of that notification, and all these notifications were silenced before this honorable court by way of filing an affidavit, PIL, my lord, by HRS Uduri in PIL number, my lord, 185, 253, and 254 of 1998.
PIL against?
Yes. PIL against those, my lords, notification of Election Commission of India with regard to devoter.
With regard to devoters.
Devoters and this, my lord. This,
Intensive revision.
Yes, intensive revision. And this honorable court, after hearing it by the division bench of this honorable court, upheld that, my lord, notification. Now, my point is, what is there in the notification?
Yes.
Did this? Yes, sir, my lord, this is, I had the monopatra one, that's why probably.
Madam, have you seen it?
Yes. They are in. My lord, may I read the notification part. Notification.
Did.
My lord, notification dated, this is in para 6 of the judgment, my lord. It is quoted in para 6.
The judgment is dated?
judgment is dated, my lord.
The PIL judgment?
PIL judgment, it is reported.
Can you give it a citation?
Dated 11/01/2002, my lord.
2000?
11/01/2002. It is in Monopatra, my lord. 2002 1 GLT 1. Notif 2002 1 GLT 1, my lord.
Yes.
There in para 6, the notifications have been quoted. Para 6, it is said, it appears that the Election Commission of India, hereinafter that commission, has issued instructions from time to time to the Chief Electoral Officer Assam for intensive revision of the electoral rules in Assam with reference to 1/1/1997 as the qualifying date. That will be the qualifying date. These instructions of the commissions are So one copy is there, madam. It is-
Notification. Notification খন নেকি অকল চাওঁ এক মিনিট নহয়
Para 6.
Para 6 টোত notification নেকি অকল মোক চাবলৈ দিছা
Para 6, there is notification is, my lord, that notification dated 1796, 4/2/97 and 17/7/96.
yes
Copies of which have been annexed in the reply affidavit filed on behalf of the commissioner.
okay
The instruction of the commissioner, which proved that the case of persons whose citizen is a doubt, are to be referred to appropriate tribunal for determination of their citizenship, are contained in paragraph 3.8, 3.9, 3.10. Now, what is 3.8, my lord? 3.8 is there. The electoral registration officer, which is ERO, my lord, shall, on receipt of the verification reports from the local verification officer, that is LVO, my lord, considers the same. My lord, here, my lord, when the Election Commission of India directed for intensive revision of electoral rolls, the ERO, the district election officers, they first, my lord, verified it. When they found that this person's names are suddenly appearing in 1997 voter list, they direct some LVOs. LVOs are not, my lord, the officers from the election office. They are independent officers from various
local
verifications. Yes, they are not from election office. So there is no case of biasness for the election. My lord, they direct the LVOs. LVO has to give a report. What report LVO has to give? Where his, my lord, the election registration officer shall, on receipt of the verification reports, which is annexed here, from the local verification officer, consider the same. He has to consider it. Where he is satisfied, that fact has to be seen. Where he is satisfied on such report and such other materials information as may be available to him about the eligibility of the person, he shall allow his name to be continued in the roll and include it in the final roll. Where, however,
that is the role of the election ERO
yes, that is the electoral registration, mother that mother electoral roll. Now, my lord, why I'm reading this portion? In the present case, where my learned friend is arguing that, my lord, the LVO has given nothing in his report. What will happen then? What situation will happen? Obviously, the ERO has to consider that LVO report. If he is not satisfied with that report, he has to send the matters to the Foreigners Tribunal for reference. If he is satisfied with that report, then he will drop the case and he will continue his name in the electoral roll of 1997. So, if the LVO cannot give any report in anything in the report, that is there is no option but to my lord ERO to send a matter to the Foreigners Tribunal. So his argument that LVO has not collected anything from the my lord person, that will not help him at all.
If
It
there
will
is
go
nothing
against-
in the LVO report, and
Yes.
you mean to say that if there is nothing in the, if it is blank or if it's nothing in the LVO report,
Yes, madam.
then the ERO
Has to
has to send the report.
send the report to the Foreigners Tribunal, because otherwise, my lord, that is the language here also, my lord, where he is satisfied, because he has to satisfy the report. If he is not satisfied, he has to send a matter. The next line is there, my lord. Where, however, he is not satisfied and has reasonable doubt about the citizenship of a person, he shall refer all such doubtful cases to the competent authority under Foreigners Act 1946. So if during LVO inquiry, the
The
petitioner,
language is negative.
yes, negative.
Satisfaction is with regard to whether the LVO has given positive inputs that he is a citizen or not.
Not.
If there is no report, then he has to be refer, he has to
Yes,
refer.
that is the simple.
That means lack of materials in the LVO would go against the
Against him only.
procedure.
Against the
Proceeding.
procedure only.
That is
It-
the language employed.
That is the language here. That's why the Siamuddin also upheld. Mala Siamuddin judgment. That is also, that point has been taken in the Siamuddin. Shukurjan also. Shukurjan also, it is same point is taken. So this is settled argument, but this is settled position. It is not necessary at all. LVO report need not be acquitted to refer the matter to the Foreigners Tribunal. It
But
is
the argument which was made, maybe it's a stale argument, but since we had considered, the argument was that there was no negative materials collected against the proceeding
that
by
is-
the LVO.
that is their argument.
Yes, that is there, which might give rise or support to the suspect,
Yes,
that the suspicion is there that he is a foreigner,
yes.
but
No,
there are no materials.
Here, my lord, here two things are there. That's why I'm saying. my
Yes,
lord.
they kindly clarify that
Yes,
issue.
first of all, my lord, when 1997 voter list was prepared, Election Commission directed to intensive revision that when you are preparing the 1997 voter list, you see, my lord, the ERO, what the election officers seen, whether this person's name have been suddenly appearing in this voter list. If he found that, my lord, if your lordship see the ERO's direction, for the time being, then your lordship will clear. ERO report is given. And it's beneath. My lord, may I clarify, 1997, when the petitioners or someone's name has suddenly appearing in the voter list in 1997, the ERO creates doubt. Where from this person has come, that is election registration officer. Once he have some doubt about that person, he will have to verify that through the local verification officer, whether his name can be continued in the voter list or not. To that effect, LVO has to give satisfactory report to the ERO that yes, these are the documents, these are the material facts on the basis of which he can be said that yes, his name can be continued in the voter list of 1997. If LVO cannot give satisfactory report to the ERO because his name is appearing suddenly in the voter list of 1997, that is the very doubt, my lord. That is the very doubt because the voter list was revised. That is because at that time, some person's name were appearing at the age of 50 years. Some persons first time appearing in the voter list at the age of 45 years. So that is the doubt, mal. And there was no ancestor where from they are coming. That's why these doubts were there. And that's why these persons those doubtful persons were verified by the local verification officer, whether he has valid documents, whether he has the legacy of staying here in the state of Assam. So for that report, LVO was asked to give a report. If LVO could not give satisfactory report, that is the language here, LVO, he has to satisfy with the LVO report, then he will continue the name in the voter list of 1997. If he is not satisfied, he has no option but to send the matter to the Foreigners Tribunal for determination. Once the Foreigners Tribunal is determined the citizenship of the person, he will allow if he is a citizen of India. If he is not a citizen of India, his name will be deleted permanently from the electoral roll. Till then, determination, his name would be, against his name, D mark would be put. That is the situation. That is the case, mal.
What are the possible scenarios in which the LVO report could be blank?
My lord,
He did not commit an inquiry or nothing, no information was found.
then no alternative but to foreigner, my lord, ERO has no alternative but to send the matter to the foreigner tribunal.
Now, here in this case, the LVO report, it's signed.
Yes,
It's
LVO
signed, LVO has said could not
produce any
document-
documents. Even in this case, my lord, LVO has said he could not produce any documents.
Yeah,
So
that is enough.
And that is,
That is why it could not be filled.
Yes, yes.
and that has been considered by the
ERO.
ERO and matter has referred to the
Referred to
referent
foreign
authority, namely the superintendent
Police.
police border.
Yes, because SP has the right to refer. Here in this case, SP had made further inquiry, but it should not have
Just
been
a
done.
minute, please. Yes,
My lord, in para 3.8, 3.9, 3.10 of the notification, it is clearly described how it will be dealt. My lord, the entire situation.
3.8, 3.9 and
3.10, my lord. Para 6, it is quoted. Para 6 of the judgment, it is quoted. Ultimately, the entire, my lord, the entire situation, this is, my lord, notification and marking of D was upheld by the Honorable Court in this judgment. So that is the point there. Now, second aspect, that is settled in, my lord, Siamuddin also, same position. And this Sukurjan Nesa also, my lord, recently in, this is referred again and again. Yesterday also this is referred.
please
Dub-
give the citation.
WPC, my lord, 245 of 2019.
Name,
Name, my lord, Sukurjan Nesa.
WPC 245.
Yes, 2019, my lord. Sukurjan Nesa. Decided on 28 to 2025, my lord.
Can you mention the citation, please?
2020, my lord, WPC 245 of 2019, my lord.
Citation. Date of the judgment,
Date of judgment
28 to.
28 to 2025. Same proposition, that proposition is upheld here also.
Para,
Para, my lord, it is quoted in para, my lord, enter this. Para, para 17, the entire thing is quoted, my lord. Then
para 7,
para 17, my lord.
17.
Yes.
20 17.
And in para 20, my lord, the Amina Khatun has been differentiated. And para 22 specifically said, therefore challenging the proceeding before the Learned Foreigners Tribunal on the ground that certain paragraphs or columns of the local verification officer's report as forwarded by the ERO was left blank is held not to be maintainable on the facts on the
There is answer.
para 22, my lord.
Quotation 7 to report quotation 20 of 17.
So that cannot be. Para 22 also, my lord. So from all these judgments, my lord, it is clear, my lord, this, if something is blank to remain, something blank remain in the LGO report also, that will not maintainable. That is a not ground for silence, and that cannot be accepted as a ground for silence. Yes.
To this, that when the columns are left blank, it is very desirable for the LVO State the reasons.
In the, yes, here it is, in fact, here it is given, my lord. He could not produce any document.
document.
Yes. Here it is. that- Yes, his accountability is also important. But my lord, the thing is that that's why I'm saying, my lord, the first instance I argued, I stated before your lordship, that my lord, they are not persons from electoral registrations office, ERO's office. They are independent persons of independent office. They cannot be biased. We cannot assume that they are biased towards the election. That's why. And if he cannot produce any documents, and second thing, my lord, this is one aspect of the case. Second thing, my lord, I argued one point, Sobananda Sunwal. In Sobananda Sunwal 1, para 41, 42, I again like to argue. 2005, 5HCC 665 in para 41, 42, 42, my lord. 41, I'm reading, my lord. Yes. 2005, 5HCC 665, which is para 41, my lord. Just I'm reading slowly, my lord. Your lordship will understand. My lord, what happened? These forms, the Annexure 1 and Annexure 2, information to be collected by the LVO. Your lordship will find there are some columns that when they have entered into India, what is the address of this person in Bangladesh? Why he has entered into India? This has to be filled up by the LVOs. And this is in consonant to the, my lord, IMDT rule. This is in consonant to the IMDT rule. And in Supreme Court in Sobananda Sunwal, it is held. That's, my lord, para 41, Rule 4. Rule 4 requires an inquiry officer to elicit information and particulars from the alleged illegal migrant on the points mentioned in Form 1. That is Form 1. Item number 5, 10, 11, 12 of these forms are as under. May I read, my lord? Address of the country of origin, village, police station, districts, community, etc. That is the illegal migrant. Does the person hold any passport issued by any foreign country? If so, further particulars. What are the reasons for leaving the person's country of origin? If the person has entered in India without passport, how person entered? All this has to be given. That is also requirement in the LVO report here. Now, Supreme Court in para 42 says, it is elementary that a person who has illegally come from Bangladesh to India and is residing here for his better economic prospects or employment, etc., would never disclose that he has come from Bangladesh, but would assert that he is an Indian national and resides in India. There is no question of telling his date of entry or giving any information on the aforesaid points. That's why, my lord, at last, this, along with all this, in para 83, this tribunal's order, 1983, the IMDT order was also set aside. Now, my learned friend is arguing that these are the necessary things which has to be collected by the LVO. And if these materials are not there, I cannot be prosecuted. That cannot be, because this has already been set aside by the Supreme Court. That is another aspect. The third aspect, my lord, third aspect of this case is, my lord, again in Sobananda Sunwal, my lord, these cases are initiated in 1997. This case, especially this case is started in 1997, pending in the ballot in different stages, different ballot bodies. Now, what Sobananda Sunwal has said, this tribunal, my lord, got its jurisdiction of this particular case by virtue of the judgment of Honorable Apex Court in Sobananda Sunwal. Now, by in Sobananda Sunwal, my lord, para 84. Para 84, my lord, Sobananda Sunwal 1, it is said.
Yes.
All cases, para 84(3), my lord, it is said. By para 1, my lord, Act 83, the rules of 84 has been set aside, struck down. The tribunal and appellate tribunal constitute under illegal IMDT, all, my lord, struck down. Now, all cases pending before the tribunals under the IMDT Act 1983 shall transfer to the tribunal constituted under the Foreigners Tribunal Order 1964 and shall be decided in the manner provided in the Foreigners Act, the rules made thereunder and procedure prescribed under the Foreigners Tribunal Order 1964. Now, these matters were pending in the Foreigners, my lord, IMDT tribunals in different stages. Now, by virtue of this direction, the tribunal got its jurisdiction, Foreigners Tribunal. And this matter is transferred to the Foreigners Tribunal. Now, can we say that the inquiry is wrong? We cannot say, because we got this jurisdiction only by the direction of the Honorable Apex Court under this clause, my lord. If they are not, they want to challenge it, they have to challenge this direction of the Supreme Court. Had there been no direction, my lord, the tribunal would not have. Now, tribunal cannot question, no, this inquiry is wrong, because it is the direction of the Supreme Court, irrespective of all cases pending in the IMDT tribunal, has to be transferred to the Foreigners Tribunal. Now, being Foreigners Tribunal, he cannot say, no, I cannot take this matter. The inquiry is wrong, this thing is wrong, because it is the direction of the Supreme Court. These matters, my lord, it is admitted position. Under the IMDT tribunal, the entire things were not correct. The inquiry was not proper. The inquiry system was not proper. The Foreigners Tribunal system was not proper.
The direction of proof was in the other direction.
Yes.
Opposite to section 9.
Yes.
Is that?
Yes, that's why. That's why it is said. That's why it is admitted position. My lord, there may be fault in the inquiry because it was under the IMDT. Definitely there may. That's why this IMDT was set aside. But irrespective of, my lord, fault in the inquiry, irrespective of fault in the, my lord, process, all these matters were transferred to the Foreigners Tribunal by the judgment of the Honorable Apex Court in Sobhana Dusunwat. Now, how can the tribunal challenge the direction of the tribunal, my lord, the Honorable Apex Court? The tribunal cannot say, no, I cannot take this matter because the inquiry is not proper. The earlier process is not proper. I cannot take this. This cannot be. So if they are not satisfied of transfer of this matter to the Foreigners Tribunal, then they have to challenge this provision of this judgment of the Honorable, my lord, the Sobhana Dusunwat. Unless until this is challenged, it cannot be. They cannot challenge it now saying that, no, this inquiry is wrong. And on that basis, this proceeding is wrong. They cannot say it now.
So this argument of yours is for those set of cases which started,
Prior to
whose initiation was at the time of
1997, prior to 2005.
when IMDT was in force.
Yes, prior to the
And
first,
by the judgment of Sarvananda Sonowal at paragraph 84(3),
yes, ma'am.
all such cases were directed to be transferred to the Foreigners Tribunal
Yes,
to act in accordance with the Foreigners Tribunal Act and the rules.
yes,
So the question of going back
yes,
to how the matter was referred will not come before the tribunal. Tribunal has to decide on the merits of the case.
merits of the case. Because it is only on the basis of the direction of the Supreme Court we are getting that power, my lord. Otherwise, we would not have. In fact, in further it is said, my lord, where those cases were
What
dropped.
about new cases? This argument of yours pertains to those cases. What about new proceedings?
New proceedings will be different. In that case, it will not, my lord, it may not come in new proceedings because new proceedings are initiated by the, my lord, department later on after the 2005. Then it will be in a different footing. Only on this point, only in this category. This will be a separate category of cases whose were registered prior to 2005. The judgment coming prior to the judgment
In
of
the earlier act which has been set aside, declared ultra virus,
yes,
the reference was made by whom?
SP only. They are also same process, my lord. Only the inquiry, my lord, these things were necessary. Where from they has come, how they has come, when they has come, those has to be given. Even then, affidavit has to be given there. And if it is found false, my lord, they were given, they were penalized for that. These provisions were there. And this has to go through a, my lord, scrutiny. Then only it will go to the Foreigners Tribunals, IMDT Tribunal. And that's why, my lord, in this judgment, it is also said, those cases which were kept or which were dropped by the scrutiny committee, those can also be sent to the Foreigners Tribunal. So that is, this is for my lord those cases. This will be a separate category prior to 2005 cases.
What is the date of the judgment?
Date of judgment, my lord, it is decided on 12th of July 2005, my lord.
No, not this, the
So-
Sarvanda Sonal,
Yes, my lord,
12th of
2005.
July,
12th of July 2005, my lord.
2005. Okay.
So, nutshell, my lord, it is clear my friend's argument that the LVO report is not correct, so he cannot be proceeded by the foreigners tribunal. That cannot be accepted on all these three grounds, my lord.
On marriage, what do you say?
Merit, my lord, the only point here is, my lord, the link certificate. He has produced 3 link certificate. He himself, my lord, my learned friend himself. My lord, where do we want, my lord? I have stated again and again, para 26 of the Sarvanda Sonal says 4, 5 things, my lord. Date of birth, place of birth, citizenship of parents, and their, my lord, citizenships. And we want, my lord, if a person is there in prior to 1971, the petitioner has to link himself somehow along with that person who's there in 1971 with a cogent, reliable documentary evidence. That must be, nothing more than that. That is the fact in it. Now, he has relied on 3 documents, my lord, but my learned friend has himself submitted yesterday that he is not relying the Kazi. My lord, if your lordship may kindly say 90, page 90 of the opinion. Well, before going to that, my lord, just like point out, my lord, your lordship has, lordships know it well. Now, this is not a judgment.
Opinion.
Yes, it's an opinion on. And opinions may not contain at all each and every facts, man. It's impossible to give everything, man. My learned friend argued that these were not considered. But in page 90, my lord, above the noted decision and decision, all these things were described. And in last para of page 91, it is from the above observations, all these things were considered. Thereafter, this opinion was passed. Now he has relied on, the petitioner has relied on 2 linked documents, my lord. One is that Kabilnama that was not proved by calling the Qazi, and he has, my lord, category, he has denied, my lord, said that he is not considering that as on now. Now he is not arguing on that point, my lord, he is not. And the GP secretary is also, GP was also not examined, Panchayat secretary. Now boils down to, my lord, the school certificate. That is the only documents he is trying to relying on now. The school certificate, exhibit, my lord, 2.
Yes.
My lord, the school certificate, if your lordship see, first point, school certificate,
It's 39.
page 39.
Yes, please.
First of all, my lord, as you, I argue again and again, my lord, this school certificate is not an admissible document for the first purpose, my lord. The national emblem of India is embossed on the top of the school certificate, which is not allowed and which cannot be used by LP school headmaster, my lord. And in fact, this school was not a government school prior to 2013. And this lady, my lord, she was reading at the school. The first ground is that the national emblem is embossed on the top of the certificate. And this cannot be an admissible document for that reason itself. Now, contents, my lord, if you lordship may see contents. If we go to the contents of the documents, my lord, one Saleha Khatun, Pita Srijut Nurul Haq. Now, my lord, this Gaon is very important.
Sand block.
Sand block. Sand block, Thana Dokhin Palmora, so and so, Dhira Juburi, চেণ্ট ব্লক LP স্কুলৰ বিদ্যালয়ত পঢ়িছিল 1992 চনৰ ডিচেম্বৰ মাহত 31 তাৰিখত বিদ্যালয়ত তেওঁ শিক্ষা শেষ হয় তেওঁ বিদ্যালয়ৰ 4ৰ্থ শ্ৰেণীত পঢ়িছিল পৰীক্ষা উত্তীৰ্ণ হৈছে and ছাত্ৰীজনীৰ জন্মৰ তাৰিখ your lordship will find in the down below ছাত্ৰী 1978
Yes.
and this certificate was issued after my lord 2016 after about 20-25 years of passing the school. First of all, my lord, as I said, my lord, the national emblem is embossed in the top, so it is not an admissible document. Secondly, the belated issuance of this certificate, why this certificate was belatedly issued, there is no explanation to that fact, my lord. She passed out in 1992, and this certificate was obtained only in 2016, and this proceeding initiated in 1997. This proceeding against this proceeding was initiated against in 1997 itself. Now, why I'm saying that the Gao is very important. As per the melody, if we see the melody voter list and her evidence also, my lord, as per this certificate, she was reading and did school in 1992 till 1992. That means this must be all this record, the whatever contents there, it should there only of the period of 19 up to the period of 1992, my lord. It cannot be beyond 1990. So whether this petitioner was living in St. Block prior to 1992, because this certificate is given on the basis of record. The certificate cannot be given, my lord, without any record. The certificate is given on record. My lord, when did he, in fact, the parents, my lord, if we see the 1997 voter
How
list,
many PWs are here, DWs are here?
2, my lord. Three.
Who is the third?
Third is the school headmaster, my lord.
School headmaster.
Yes,
He had come.
he had come, my lord. He had come.
Let us see his deposition.
Page 86, my lord, vernacular. We have, your lordship has seen yesterday, my lord. Page 86 is the vernacular.
86.
Yes.
Headmaster.
DW3.
Yes.
Abdul Kadir Niyam. He is the headmaster. LP school headmaster,
Yes.
Sunblocks, Santinagar LP school.
Yes.
Exhibit 2 মই দিয়া certificate. Exhibit 2 1 মোৰ সহি প্ৰধান শিক্ষক হিচাপে. Exhibit 2 খন সালেহা খাতুন daughter of নুৰুল হক of St. Block দিয়া হয়. OPA ক্লাস 4 লৈ পঢ়িছে. মই সেই হিচাপত exhibit 2 খন দিয়া হয়. মই ID লৈ আহিছো. আজি মই admission register খন লৈ আহিছো. Page 13 serial number 20 OP নাম লিখা আছে. Exhibit 2 so and so admission register আৰু OP নাম থকা page আৰু exhibit so and so উক্ত exhibit certificate খন page so and so মূল বহি certificationৰ পৰা exhibit 26 মোৰ সহি. Now it cross he said exhibit 2 খন 5/2/1/2016 তাৰিখে ইস্যু কৰিছো. 1983 চনৰ পৰা উক্ত স্কুলৰ হেডমাষ্টাৰ হিচাপে কাম কৰিছো. 2013 চনৰ পৰা গভৰ্ণমেণ্ট স্কুল হয়. 1985 চনত এডমিশ্যন লৈছিল আৰু OPA 92 চনত স্কুলৰ পৰা ক্লাছ 4 পাছ কৰে. তেতিয়া স্কুলখন চৰকাৰী আছিল. Exhibit 2-3 খন মই হেডমাষ্টাৰ হিচাপে চাৰ্টিফাইড কৰিছো. যদিও মই উক্ত স্কুলত 1983 চনতহে হেডমাষ্টাৰ হিচাপে কাম কৰিছো. মই 1979 মই উক্ত স্কুলত মই নাছিলো. তেতিয়া লাক্কা আলী হেডমাষ্টাৰ আছিল. লস্কৰ আলী. Where is the evidence? Ma'am?
What is his age? 56 at
Yes,
the time of deposition.
yes, 56
Deposition was when?
on 2016, no, 18, my lord. He was above 18, my lord, in 1982. Now, what my submission is, my lord, if your lordship may see, this certificate is of period of 1985 to 1992. Saying that during this period, she was a student of this school.
No, till 1992.
1992. That's
Yes,
right.
31/12/92 she
90
left.
Yes, from 85 to 92, in between this period. Now, my lord, she was a student of this school. If she was a student of this school, and record should have revealed that where, my lord, at that time, she was not a resident of Sen Block. He was not a resident of Sen Block, my lord. If your lordship may kindly see, even the parents, page 30 is the voter list of 1997.
30.
Yes. Page 28 is the voter list of 1989. Page
Page
28.
28.
Yes, 28 is of 1989, when probably the petition was written in the school, if the contention is correct, madam. The village is Zorna Sor Part 3. Page 28, madam.
Village.
Village Zorna Sor Part 3. And even in 1997 also, they were not resident of Sen Block. They were resident of Sirakhua Part 3 and Sioux Block. 89 is Zornarsor Part 3, page 28. Now, first voter list in Sen Block is 2005. My lord, your lordship will find page 37.
30?
Page 34, my lord.
34.
Yes. Voter list of 2005 of projected for the parents, my lord. They came to Sen Block
2005.
2005. So by no means, my lord, the petitioner can be a resident of Sen Block during 1985 to 1992. This is totally a manipulated document, in fact, I'll say. Yes, yes. No, that is in record. If your lordship see the record, probably the record of the school is there. Page 62 in the record, LCR, my lord. This year, my lord.
That means prior to 2005, there is no document to show that they were residents of Sen
Sen
Block.
Block.
Whereas in the school certificate, which is of a period of 85 to 1992, the petitioner has been shown to be a resident of Sen
Sen
Block,
Block.
which is not supported by
Not
the other
supported by-
document. That is precisely your case.
Yes, that is one aspect, my lord. Another aspect, my lord, in the certificate, if your lordship may kindly see, the date of birth is given.
How long will you take, Mr.? We'll come back.
Yes, sir.
5 minutes.
Another thing, your lordship, if your lordship may kindly see the record, trial court record, my lord, this year. Page 62 is the record, my lord. This certificate is not given on the basis of record, my lord. What record transpires. Page 62 in the record. The last entry is the of the petition. If your lordship see, the entry itself is doubtful, but it is not recorded in the opinion because it is the last entry, and there is no undermarking. And second thing, the village name is not village name is your lordship makes.
10 block is there,
Yes, that cannot be
or it's
because
not matching.
not matching. And third thing, my lord, where is the date of birth is written? He has given in this certificate her date of birth is 31/12/1978. This should be the basis of record. Record, nothing is there. Record only said at the time of admission, she was 7 years old. Second piece, probably the second piece. The age is mentioned, 7 years. No date is mentioned. No date of birth. How this petition, the headmaster could put this name, date of birth, in this certificate as 31/11/1978 in 2016. If your lordship see the entry also, the entire names above para 28 were entered in a proper manner. All touch the above line. But this entry is not touched. It is in the middle of the house, middle of the road. And this, according to him, this register book was maintained, and
This is by a different handwriting also.
yes, this is a different handwriting also. And now, my lord, this headmaster has said that if your lordship is in the right, extreme right, probably there, the signature of the headmaster is there.
Where?
In the extreme right,
Right. Of page
63 probably, my lord.
63, next page. In the certificate,
No, in the, my lord, 62 itself, my lord, proper.
there is no signature of the headmaster.
Record, my lord.
Record, yes.
It's shown that signature of the headmaster. No, in the entire house, entire columns, my lord, the signature is there. Against entry, each entry, there is a signature, my lord. Who entered that, my lord? May I see the record for the time?
Sorry. Did this.
And according to this, the page 63, my has been yes. Okay.
Found.
Okay. The right, extreme right, that is the signature of the headmaster who entered the mallet entry,
Yes.
according to him. And as per this, that is the signature of the mallet, as per the statement of the headmaster before the tribunal. He was there as headmaster since 1983 to 83. And this is not his signature. The signature is there in page 39 of the present headmaster, mallet, in the certificate.
Yes.
So this document is totally doubtful, my lord. The date of birth is not mentioned in the record, but he has mentioned in the certificate, which is issued on 5/1/2016. So if this certificate is not there, there is no other evidence to link himself to the projected father, Nurul Haq, my lord. This, my lord, why this document cannot be accepted? I have given 3 points, my lord. First of all, my lord, the state emblem is there, which is not permissible. Secondly, my lord, the certificate was issued well after, my lord, 25 years, which is where there is no explain at all why this certificate was issued after long delay. Thirdly, my lord, the contents, the village name is the person, but even in my lord, WSN evidence itself, she has said they shifted to this village later on, my lord. During this period, they were not there. It is there in the WS also, even in evidence also. So during this period, they were not resident of Sen Block. They came to the Sen Block after 2-3 shifting of 1971, my lord. The detailed shifting is given. So she cannot be a resident of Sen Block. This is only given only in 2016 when she is a resident of, my lord, Sen Block area, Sen Block phase. And number fourthly, my lord, the date of birth is not mentioned in the record. But where from the petitioner, but the headmaster could put this date of birth? This has to be, my lord. And one more thing, my lord, she took admission in class 1 in she may have failed, but she took admission in 1985, passed out the class 4 examination in 1992, after 7 years. And this school was not a government school, madam. This school was not a government school. It was provincialized probably in 2013. So if the school certificate is not there, and he has submitted, my lord, the Gambura certificate, the GP certificate is not proof. My lord, the another link certificate, the Kabil Nama, they are not relying on the Kabil Nama now because it is also defective. So there is no documentary evidence at all to prove link herself to her projected father. Apart from other, my lord, discrepancies, I'm not going to that. Now, my lord, the one judgment of the Supreme Court, it is upheld by the Supreme Court in this case, my lord, 2025 SCC Online SC 1160, my lord. 2025 SCC Online SC 1160.
Name?
S 1160.
Name?
Rafiqul Haq, my lord. Rafiqul Haq. ROFIQUL Rafiqul Haq.
HO or HA?
RO, my lord.
HO or HA?
HO. HOQUE. Here is the case, my lord. In this case also, the school certificate was relied. However, in that case, the headmaster did not come forward. But issue here was, my lord, if your lordship may see, para 15, my lord, there just I'm reading para 15 in this judgment.
Yes.
The tribunal as well as the High Court have considered this document and found that those earlier voter lists related to persons located in some other villages than one of which appellant claimed to be a resident. In such circumstances, the appellant ought to have stated in the affidavit or demonstrate by some documentary evidence that his ancestor had migrated from village to other villages where the appellant was reported to be residing. But according to tribunal, there was no such claim by the appellant in the affidavit. Therefore, the tribunal discarded the probative value of the voter list of entries. I am not on that. Now, by the next part. Interestingly, the school living certificate on which heavy reliance was placed by the appellant was also doubted as there appeared no reason for it to have been obtained 10 years after passing from the institution. So this, moreover, in that case, my lord, the headmaster of the school was not called as a witness. So this portion, my lord, I'm not saying delay may be there, but reason must be recorded. Why they obtained the certificate so delayed manner? This explanation is not there. 2016, we have to remember that this case was initiated in, my lord, 1997. Certificate was obtained in 2016. Describing a fact of minor 1985 to 1992. So another judgment of this honorable court, my lord, on a school certificate. Reported also. We say. This man reported, my lord, but I don't have the reported person. This is WPC 7756 of 2016, my lord.
2016.
Yes, 7756 of 2016.
Name?
Khudeza Khatun, KHUDEZA, Khudeza Khatun, KHATOON. Decided on 26/4/2018 itself. This is
26/4.
6/4, 26/4, my lord.
2018.
26/4/2018. There in para 12, my lord. 12 details of this. Just I'm reading the 12th person. Exhibit A is the transfer certificate dated 9/1/2016. Issued by the headmaster of Uttar so-and-so school, certifying that so-and-so was the daughter of so-and-so village under Moirabari police station in the district of Morigaon. She had left the school on 31/12/1988 after passing class 2. As per admission register, her date of birth is 12/1/1981. The certificate cannot be accepted as a valid piece of evidence for more than one reason. Firstly, the state emblem of India is embossed in the certificate. The state emblem regulation use rules 2007 has been framed by the central government in exercise of the powers conferred under section 11 of the state emblem of India, Prohibition of Improper Use Act 2005. This act was enacted by the parliament to prohibit improper use of state emblem of India. Section 3 specifically prohibits improper use of state emblem. It says that notwithstanding anything contained in any other law for the time being in force, no person shall use the emblem or any colorable imitation thereof in any manner which tends to create an impression that it relates to the government or that it is an official document of central government or the state government without previous permission or authorization. Headmaster of LP school not authorized to use the state emblem of India in any manner. Thus, unauthorized use of state emblem of India has rendered Exhibit A inadmissible in evidence. That is the point. The certificate was issued 28 years thereafter on 9/1/2016. Such belated issuance would necessarily cause serious aspersion on a bona fide of such certificate, which is heightened by the unauthorized use of the state emblem of India, that too not as per statutory format. Here also it is not as per statutory format. The certificates of the school has to, it is written in the opinion also. The certificate has to be issued. Certificate is printed in the government press, not in any other press. It is printed in some other press, my lord. It is written in the here also. So it is not in the format. So in this case also, my lord, that's why this certificate was not accepted. Here it is relied on, my lord, how the date of birth of school certificate has to be proved, settled by the Supreme Court in Virat Mal Singhvi case also, how school certificate has to be proved. Entry who met the school certificate, my lord, school register, he has to come. And that has to be on the basis. And so If the school certificate is gone, there is no other document because the Kabilnama is not, Kabilnama is defective. My learned friend is, my lord, relinquishing that argument. And my lord,
No, you are, yes, sir, Mr. Ahmed may be correct. From the beginning, you are saying that Kabinnama has not been relied upon, but there was no such statement made.
yes, no, he is now not, he said that he is not relied. That I can argue on the Kabilnama also, my lord, my learned friend, as my learned friend yesterday said, I'm not relying on the Kabilnama, that's why I'm not arguing. Panchayat certificate is not proof, that is. Kabilnama, it is already, my lord,
No,
there.
so far as Secretary GB is there, he said that it was not proved by the person author, so he is not relying upon. Kabinnama he is relying upon.
Kabilnama is also not proof, my lord. It is the authority has not come. Kabilnama also, the authority has not come to prove that Kabilnama. It is not. And this marriage, my lord, as per the, my lord, the Kabilnama, the marriage was solemnized on 2/12/1995 and it was registered by district agent 35/2017, which is not permissible at all. It has to be registered within 1 year, 1 month.
2017 when registered?
35/2017, my lord. Marriage solemnized on 2/12/1995.
And registered in,
Registered in 35/2017, my lord.
has to be registered within.
Within 1 month.
What is that? Can you repeat the judgment on?
Yes.
Filling of school certificate?
Yes. My lord, the
The Singhvi case you are just,
oh, yes. Biratmal Singhvi.
yes.
Biratmal Singhvi versus Anand Purohit, my lord.
Give the citation,
Yes,
please.
1988. Supply SCC 604. 1988. Supply SCC.
How is Virat B or V?
BIRAD.
V for victory,
No, my.
B for Bharat,
Yes, B for Bharat.
BIRAT.
BIRAD Birat Mal Singhvi. SINGHI versus Anand Purohit.
Anant.
Anand. ANAND. Anand Purohit. The government, the Panchayat certificate is not proof. My lord, if your lordship make see, during NRC time, my lord, the authentic document for this kind of ladies who were migrated, who changed their place due to marriage, the GP certificate was allowed. The GP certificate was allowed, but it has to be on two rider. My lord. First of all, the authenticity of the document has to be proved. Secondly, authenticity of the contents of the document has to be proved. Rupjan Begum, my lord, Rupjana Begum in that case. But they have left that, my lord, GP certificate, though it was submitted. They did not try to prove that GP certificate here in this case. Now, there are numbers of judgment with regard to, my lord, these Kabilnama also, that it has to be registered within 1 month. Even the statute says it has to be registered within 1 month. If it is not registered, and secondly, my lord, there are numbers of formalities. This is not a government kazi. Government kazi, the register has to be issued by the, my lord, register of marriage from the district office. Only in that case, my lord, it can be registered. These are private cases, my lord. Private cases. Good. Short kazi. Government kazi na ho. The register Kazi did not call for proof the exhibit one Mary's Kabir-nama. That is also not proof. Kabir Kazi. Okay.
Yes.
And for Kabir-nama, there are numbers of judgments. I would just like to point out two judgments, madam, of this honorable court. This is, my lord, WPC 2294 of 2016. 2294 of 2016. Hamida Begum, my lord. HAMIDA, Hamida Begum. Decided on, my lord, 6/6/2018 itself. There is para 26 and 27. madam. Proceed to exhibit 4. Accordingly, the petitioner is a Kabir-nama dated so and so regarding marriage of the petitioner with Abdul Sukur. As rightly pointed out by the tribunal, the document was written on a plain piece of paper and for all intent and purpose was private document. If that be so, then it was required to be proved in accordance with law. At this stage, we may point out that Abdul Shukur, whom the petitioner claimed to be her husband, did not come forward to depose before the tribunal in favor of the petitioner. Neither the Qazi, who had performed the nikah, nor the person who were present at the nikah as witness deposed before the tribunal to prove the exhibit 4. Therefore, exhibit 4 not proved. So it is not. Secondly, my lord, in another judgment, this is, my lord, WPC 6344 of 2016.
What proposition?
Same proposition, my lord. The cabin 6344 of 2016.
16.
Yes, 6344 2016, Rukia Begum. Rukia Begum, decided on 29/05/2018. There it will be at para 26, my lord. In respect of exhibit 6, which is state to be Kabinnama dated 8/5/1991 between petitioner and Abdul Malik. Though in this document petitioners describes as daughter of so and so, in the absence of any authentication by responsible and competent authority, no credence can be placed at exhibit 6. As matter of fact, none of the witness of exhibit 6 nor any Kazi deposed before a tribunal to prove the contents of exhibit 6, or for the matter, Abdul Malik did not appear before the tribunal to say that he had married Rukia Begum as per Kabinnama dated so and so. Moreover, as rightly pointed out by the tribunal, exhibit 6 Kabinnama is not in prescribed form as maintained by the office of the Kazi. Therefore, no reliance can be placed on exhibit 6. On those things. And there are other judgments also, I could not find it now. But it has to be, even the statute says it has to be registered within 1 month. And the process of registration, in fact, Malat, the government Kazi, they has to give, they will be given the register by the office of the marriage register, Malat. Yes, then only they can register. Otherwise they cannot. So for all this purpose, what my submission is, Malat, apart from others, the link document, he has no link document at all. If link is not proved, I'm not on that, my lord. There may be some minor mistakes, minor discrepancies in the name. I'm not on that. But first, they has to prove it by, my lord, credential evidence that I'm the daughter of so and so. That mustn't. That is not proved. And oral evidence, your lordship, I have said the brother's evidence, mere oral evidence should not do. If it is not.
Mr. Ahmed has today relied upon the judgment of Karim Ali. 2022-3 GLT 816 para 53.
Yes. Karim Ali has not considered, my lord, all earlier judgments in that way.
No, but Karim Ali, I have already pointed out also to Mr. Ahmed, that is not the principle of law.
Yes, that is not.
On those
principle
facts,
is not.
it has been stated that the evidence of the brother was fully supported.
Brother supported, my lord, with documents, if somebody support, it's okay, good enough. We are not on that. Document is there along with documents, if somebody supports that, and that is good enough. But first of all, document has to be seen. For corroboration purpose, my lord, one may come. We are not on that. But only my lord, oral evidence, without documentary evidence, it will not, my lord. That is the proposition in Bijoy Das, as well as, my lord, the other two judgments which I have been later. Bijoy Das is clear, my lord. In fact, in this judgment, my lord, Karim Ali, the Bijoy Das and other two judgments were not considered.
So that's the comment, if I've understood correctly, that if the documents are not linking up,
Yes, my lord.
then the other evidence.
Oral evidence will not do, my lord.
Not make a difference.
Yes, would not make a difference.
But the expression which the coordinate bench has used in the case of Karim Ali is the direct evidence is there. Maybe oral in nature, but it's direct evidence which comes from personal knowledge. But yes, of course, Vijay Das and the other one
Yes,
is also
Bijoy Das
there.
doesn't.
Father's evidence, mother's evidence.
In
Because
fact,
that
my lord, if we accept, my lord, that case, father's evidence will be direct evidence, mother evidence will be direct evidence. That is negated by this honorable court.
no, see, we have also tried to understand the logic behind this. In any other proceeding, if a mother says that so and so is my son or daughter, then there not be requirement of any further documentary corroboration. But in a matter of this nature, taking into account the scheme of the act, what is the act for, the long history, of litigation, including the IMDT's tracking off and the problem faced by the country. Under those circumstances, this has been said. Otherwise, if a person,
Yes,
woman says that so-and-so is my son or my daughter.
in normal circumstance, it has to be accepted, my lord, but this is, my lord,
In the context of a foreigner
foreigners.
issue,
Yes,
it has to be corroborated with some
documentary evidence. That is the context, my lord. Because, my lord, the Somananda Sonal, it is said, it's a, my lord, war against the state. The word used this, my lord, it's a war against the state. So in that case, anything can be
External
So-
aggression.
aggression, external, it's an aggression.
Too much of, control migration can definitely take the color of that also. In that backdrop, it is
Yes,
there.
that, so it has to be, my lord, it is said that it is the duty of the state to protect the integrity of the country. That's why. Bijoy was, my lord, in para 17. 2019, 3 GL.
3 GLT.
No. Yes, 2018, 3 GLT, my lord, 118. Para 17 it is. In fact, my lord, what I have read some extent to other countries also. Some other countries, they, my lord, in fact, this not in our country. We are not probably this aspect was not gone into. Any certificate, my lord, as early as possible. If possible, before 5 years of, within 5 years of birth of the person. Any certificate, even if it is used by some missionaries, some organization also, those are accepted in those countries. But it has to be within 5 years. Within 5 years from the date of birth.
But
That's my submission, my lord, that, and these, as your lordship seen.
Would like to rejoin anything?
My landed update on this school certificate and date of place of birth middle. In the voter list of 1979, a village known as Jagdashwar middle, and petitioner was born
In the election.
petitioner was born and
But 79 is Zabrachar. 70, you say, when? So see, if in 89 you were in your parents were in Jabrasar or Jharnasar, what is it? 70, 89. Yes. Now come to page 29 also. 28, they are all in Jharnasar, part 3. Now in the school certificate, yes. Where have you stated? That in spite of shifting to San Block, your name was in another. No, no, have you stated? Have you stated? Then, no, you cannot have an answer to everything unless you have already explained. See, you are relying upon the school certificate, which says that you are from San Block. Mr. Payang is criticized that you could not have been from San Block. School certificate is for a period And for 78 and 79, parent's name is in another place. Your answer could have been acceptable if you have, this position would have been explained in the written statement. Though we had shifted in 78, names of the parents still continue to be in Zabrasar. That is not your case. When? When? Sen Block, when? 2005. Till 2005, where were you? Huh? 97, you were in Sen Block. Let us see page 30. Where do you get Sen Block? Not clear at all. It's not clear at all. Absolutely unclear. How do you manage to give this? Even in your translated copy, you have written a Chio block. You have written. We have not. No, that is your word. Even if you could not decipher what has been written. You write Chio block. But it is also of 1997. And your school certificate says what? From which school certificate? 85 to 92. '85 to 1992. Okay, considered. Okay, A.M. Ahmed, J. Payne, G. Sharma, P. Sharma, H. Cooley on behalf of A.I. Ali. No? CGC, who's CGC? Mr. We look for Mr. These are matters of very importance, grave importance. We do not find CGC in most of the cases. Final hearing, we can understand. You may not have a road is covered, but even for accepting notice, we have to look for CGC. Assume that you are present in the court. We ask whether Mr. R.K.D. Chaudhary is seen in the court. If the answer is yes, R.K.D. Chaudhary is there. This is not done. If you do not appear, we'll record you're not appearing. How many CGC do you have? 28. No, what you do internally is not our business. We want a CGC to be here. This matters. If you are not even accepting notice, what can we say? You may choose not to accept. We'll record in our orders. Rest you will follow. Why should we have to ask every time who is present in the court? Have you seen him? Because we don't want to record somebody's presence who is not even in the court. Not to talk about the courtroom. Please look into it. Please look into it. Please look into it. It's not that difficult to sit. It's not required to even prepare a case. please do, yeah. That is, here we are recording your name or who's appearing, okay. Okay. We'll consider. এইটো থব লাগিব এইখিনি সেইটো সেইটো কেছত কৈছা অৰ্ডাৰ কেইটা ইফালে ইফালে দিছে ৰিপৰ্ট কৰিম নাপাহৰিবা দেই আজি কৰিব Item 7.
This, I goes back to Bombay and it is somehow cannot, after she was declared as a foreigner on 31st August 2016, it came up in the petition, my lord, so please to uphold the tribunal, petition. And then we went in specially appeal to the Supreme Court with a lot of papers that were there that showed that she had been in India. She came as a toddler at the.
No, after the CA, will you take some steps? You may get the benefit of CA.
Since she's been in 1954. So she always been an Indian citizen.
No, the opinion is against you. No. Yes. So that is why a review was allowed.
Maybe if this matter goes back, my lord sets aside the order of 31st October, stays the deportation, and then we put these papers before the.
Without hearing you, you cannot.
My personal understanding of CA, she is born under that, because it would be right of the Indian Passport Act, but not the foreign language that she's been here, right through from the 50s.
Then you have to advance your argument. You make out a case for remand. We will remand.
Because the tribunal records were also called for by this court. I don't know if they have come yet.
Records have come. Asset records can no? No?
You can show the document.
2017 order. Huh?
My lord, any given date and date. Of the secretary, and they would not have a chance to debate.
Okay. Heard. We'll have the records. Heard Sri P. N. Chaudhary, learned counsel for the petitioner. Also heard Sri so-and-so, huh? Full stop. It transpires that the writ petition was earlier disposed of vide an order dated 11/6/2019. Full stop. However, the said judgment was the subject matter of a review petition which was allowed by vide an order dated 25/1/2023, and accordingly this matter has been listed before us. Full stop. Not 25. Review order is of 25/1/23. No, not us. Justice A.M. Buzarbura. Cannot be of 25. 25/1/2023. That was the review allowed. Review is allowed, yes. Then that's what I have before us. Full stop. It however appears that the records of the tribunal has not been called for after allowing the review petition. Full stop. Such records would be necessary for a fair adjudication of the issue before us. Where accordingly, we direct the records to be transmitted to this court from the learned so-and-so tribunal, in so-and-so case. Para list along with the records of the tribunal. Puts of the records of RP 118 of 2021, which was disposed of wide order dated 25/1/2023, may also be tagged. Yes. Yes, see, yes. Are you in touch with the clients or not? No, not 1 week. We'll have this on Friday. We'll close this. We'll give you liberty. We'll give you liberty. Day after tomorrow. Miss Kanungo, S. Kanungo, learned counsel for the petitioner, is granted time to obtain his necessary instructions as to whether the petitioner would like to explore her options under the CAA. Full stop. List on Friday. Date, huh? Item 11. Matter. None appears for the petitioner on call. First, we have also noticed that though notice was issued wide order dated 2/9/2019, returnable by 4 weeks, with a direction to list for admission after the returnable date, the matter has been listed after a period of more than 6 years. Full stop. Be that as it may, in the absence of the petitioner, this court is inclined, in absence of the learned counsel for petition, this court is inclined to adjourn the matter for a period of a week to give further scope, further opportunity, full stop, registrar judicial to inquire as to why the matter was not listed as per the earlier direction.
Item 12.
Yes, where is Mr. Ahmed? Are you appearing in item number? Item number 12. Yes, what is your prayer timing? Okay, we'll have it at 2 o'clock. In the second half. Okay. Yes. 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 We'll pronounce the judgment at 2 o'clock with another coordinate bench, sister. Then we'll sit. Okay. Yes. Who's for the, you're there? What is there any mode prescribed for making the payment?
Electronic.
Make a demand draft, matter answer, it's up to you. Why should you indicate? You put it by demand draft or a banker's check. Okay, we'll clarify it. Where is the? Oh, no, we're passing the order right now. We'll clarify that. Which order? Six, eight. In terms of the no, this court wide order dated 6/8/2025 had directed the state to deposit an amount of rupees 2 lakh before the registry of this court within a period of 2 weeks. Full stop. Para. Though the matter was listed thereafter, further time was granted to the state to make the deposit. Full stop. Sri Dinath, the learned senior advocate, has submitted that while the sanction for making the deposit has been made, the registry of this court has informed that such payment can be made either by made by demand of public banker check. In intracity, you will not get demand draft. It will be banker check. Full stop. Para. Demand draft is not. It's not an available mode in the inside the state, inside the city. It's only demand banker check. It doesn't matter. Public no, so I could demand draft corporation. We clarify that the aforesaid amount may be deposited in the registry by way of a demand draft public banker check within a period of 2 weeks. In view of the aforesaid facts and circumstances, we have the opinion that the impugned order dated so-and-so passed by so-and-so does not call for any interference, with petition being devoid of merits is dismissed. Sister.
Yes.
35 will not reach. Don't worry, we'll not take it up. We will not take it up. Don't. You had passed over for the time being. Now you're saying for the day. Tomorrow for a year. Next week, sure. 19 matters. Order 2029-3. 29-3. A prayer for adjournment has been made on behalf of the petitioner. Full stop. Para list after a week. Para. We have however noted that while notice was issued on 29-3-2019, comma, the matter was directed to be listed for admission immediately after 3 weeks. Full stop. However, the matter has been listed today after more than 6 years. Full stop. Raised for judicial to cause an inquiry and submit a report. No, not only into 3 months, including an observation that the interim order would continue till then. उसका बाद registry, huh? Item number? 14. 19 matter, we don't adjourn matters like this. Same order, last wall of it. Huh? Registry, inquiry. Same order. Issue notice 6. Returnable 6 weeks था इसमें, उसमें 3 weeks था ना, 6 weeks. Mr. Day, what is this? Why? You can start with the facts. Where is your brief? What are the facts?
As the post of APP was lying vacant.
Page 69.
Page 60. Lecture pieces.
Where is 60?
Yes, Mr.
Petitioner's father, grandfather's name is late Kushal. And then grandmother's name also is Vicky. And petitioner's father's name is late Zohin Baksa alias Zohin State of State. Petitioner's father.
Just a minute, just a minute, please. Order dated 15/3/24. 15/3/24. Yes, what is your case?
Petitioner, grandfather, my lord. Kudu Sardar and grandmother House Bill.
Where, which voter list, which one? Page 19,
Page 19.
19.
19. This is the NRC of 1951.
NRC, yes.
And petitioner's father's name appears at serial number 8.
Rohim.
Petitioner father says too much name.
Yes.
Petitioner father said one is Buledan Nessa. Her name appeared at the NRC in 1950 at serial number 11.
Yes.
Buledan Nessa.
Mother of the proceedee.
No, my lord, she is the state. And the petitioner's mother's name is Chandravan Reddy. Her name appeared in the subsequent voter list. My lord. My lord, in Annexa P1.
This NRC was exhibited. No. Not exhibited. So it's not a proof document.
My lord, exhibit. Yes, it was submitted. My lord.
As exhibit?
One.
Exhibit 1.
Exhibit 1.
Record. Record. Yes.
This is Penal Kotia of 1962, my
Page?
page, my lord, 22. The vernacular is page 22. And petitioner's father's name, serial number 2, inbox.
Fortean is of which year?
This is 1960, the next page, page 23. Page 23. It was issued on 1962.
Where do you get?
My lord, the bottom, my lord, the popping pipe is that line column, my lord, right side. The date is given 1960.
Okay.
Then my lord, annex page 24, photo list of 1966. Here my lord, page 25, the inbox says petitioner's father name appeared with his mother, Chandraban Nesabi. It's a biological mother. Chandraban Nesabi. Interestingly, my lord, age was not mentioned in that voter list. So, my lord, the London Tribunal has examined the election officer, my lord, and he has given a report before the court on 3/9/2019. My lord, it is reflected in the judgment, my lord, page 71. So he himself, my lord, said that it is there wrong, it is not mentioned. Actually, this voter list is correct. Then, my lord, 1970 voter list, page 26, 27. So inbox 8, Chandraban Bibi, Ansar Ali Sheikh. Ansar Ali Sheikh, my lord, is the stepbrother of the petitioner.
This is 1970.
1970. This was also exhibited at Exhibit 3 and the voter is exhibited at Exhibit 3. Anal Kokian also exhibited at Exhibit 2. My lord, 1977 voter list, my lord, page 29. 29. 1977 voter list, my lord. Petitioner's name appeared with his mother, Chandraban Bewa and Amjadar. Father's name, petitioner's father's name, Rahim Box. Chandraban Bewa, wife of Rahim Box Singh. In the meantime, my lord, his father died. Even the printed copy also, my lord, 1977 voter list, page 30. Serial number
What is the difference between your age and your mother's age? Age difference? In
Age difference, my lord, age difference is there.
how much? Please say.
It is, my lord, as per 77 voter list, it seems 10 years, my lord, but
Mother is just 10 years older than you.
we are, my lord, from the very beginning, age is anomalous, from the 1966 voter list.
No, this is the first voter list with your parent. First voter list. You with your parent. This is the first voter list, 1977. And you are aged 25 years, your mother is aged 35 years.
Difference is there, age difference is there, but it does not affect the family structure of the petitioner. All the
Mr. Dey,
others, if your lordship see the sequence of his family background, my lord, it tallies. So the age, my lord,
Mr. Dey, we are examining this matter in the context of one Amjad, not in the context of Chandrabhan, in the context of Rahim Bucks, in the context of Khudu Sarkar. You have tried to build a linkage with Khudu. Khudu's son is Rahim, Rahim's son is Amjad. And your mother, you have said you have a stepmother, whom you have said stepmother is okay. Golezan is your stepmother, Golezan. Golezan is stepmother. And your own mother is Chandrabhan. And the difference of age is 5 years.
10 years.
10 years, sorry, 10 years.
we cannot, age difference is there always in the voter list.
Always.
So many decisions also, my lord, in the honorable courts that they.
No, little bit of inconsistency we will accept. But
My lord, I will say 1985 voter list. It will tell you the age of the mother and the son also.
79 was it exhibited? 79, did you exhibit 79? 77? Exhibited? Where?
Exhibit 5.
Exhibit 5.
Exhibit 5.
And what is
85
what is page 30? What is page 30?
Hello, page?
30? Okay, the main, okay.
Now it's 50 years. 20 years.
Then, see, 85 voter list. Page 32. Chandrabhan Baba, Amjad Ali. Here is the age, my lord. Chandrabhan Baba 50 years and Amjad Ali 30 years. So it tally, my lord, age difference, my lord, if you are in the voter list, my lord, anomaly is common. Common. That's why, my lord, this honorable courts in some decisions, it is held that mere difference of age should not discuss the entire family background or the family structure.
1985 list, the difference is 20 years. 50 and 30.
50,
Yeah.
and 20 years difference.
That much is realistic.
Then 97 voter list.
Just a minute, please.
Seven.
So, my lord, from the 1962 to 1951 onwards, my lord, it is there. Family background is there, right? Father, grandfather, father, mother, the petitioner's name, it's come chronologically. And all these things he has stated in the doubtless list. Can you see that up? At page 44. has exhibited all these documents. But the landed court below held it due to haste.
What is page 34, 33? 33? 33 is not certified. 97 list.
Printed copy is given, my lord. Certificate copy is not obtained by him. And the 2010 also, my lord, certificate. copy. That is page 36. 36. Then the photo identity card issued in 2013, page 43.
Yes, what do you say?
Page 4. Paragraph 2. The Sultan authority instituted the breach against the opposite party for proper and hence the case of litigation dismissed against the opposition. Then the opposite party is a genuine citizen of India. He born and brought up at the village Chalapuga, and the opposite party's father or father also born and brought up in the same village, that is village Chalapuga. Opposite party grandfather name Kudu Sheikh and grandmother's name Ausipi. Both are died before the born of Opi. Opposite party's father were 4 brothers, namely Abdul Jabbar Sheikh, Rahim Bakso, Ilyas Baksha, Asiruddin Sheikh, Gofur Ali Sheikh, and of his mother's name Chandravan. They are all died. Opposite party were 5 brothers and 2 sisters. Their names were Ansar Ali Sheikh, deceased. Jamshed Sheikh, deceased. Shamshed Ali Sheikh, deceased. Amjad Ali Sheikh, OP, opposite party. Toshiran Bibi, Mona. Opposite party's wife's name, Shukur Banu Giri. Opposite parties have 4 sons and 1 daughter, namely Johar Ali.
You can skip this. You can skip this part. His children are not very important. His parents are important.
That it is the handwritten portion, my lord, it is important, my lord. The opposite party have 2 mothers, Gulajan Nessa, stepmother, Chandraban Bibi, alias Chandraban Nessa Bibi, biological mother. And then paragraph 4, the office father's name, Rohim Baksha, alias Rohim Baksha. Grandfather's Kudu Sheikh Farkar Kudu Sheikh, including other family members. Their name was recorded in the annals 1950. Then my lord, Botanist has the, my lord, a recorded my lord here, page number 6, Botanist. Here is a statement of shifting, my lord. Thereafter, office parents, residential house and landed property was eroded by the river Brahmaputra. Then office parents who shifted from village Chalakura to village Borkolia, Naskala.
Which paragraph you are reading?
Paragraph 6. Thereafter, the office parents, the residential house and the landed property was eroded by the river Brahmaputra. Then office parents, our parents who shifted from village Talakura to village Borkoli, Naskara, PS South Salmora, and office parents named Rohit Baksh, Rohit and Chandraban Nessa Bibi jointly have been recorded in the voter list of 1956. Village Borkolia, Naskara, by the house number so and so. Voter list 1966. Then para 7, my lords, this in the voter list of 1970, office parent is Rahim Baksha Sheikh and Chandraban Bibi and the office elder brother named Ansar Ali Sheikh have recorded at village Borkolia, Naskara by the house number 64, serial number so and so. The voter list of 1970. Then my lord, paragraph 8. Thereafter, the office father died, and the office name Hamdad Ali had been first time recorded in the voter list of 1977 with his mother Chandraban Rao. In the voter list of 1977, at the village Borkolia, Naskara with common house numbers also. In the meantime, due to delimitation of Assembly Constituency 32 South Salmaria LSC converted to 22 South Salmara LSC. Annexer 5 is the voter list of 1977. That subsequently copy got married with one Shorbanu Bibi. Hence, in the voter list of 1985, have recorded the office mother's name Chandraban Rao, office name Hamdad Ali, and his wife's name Shorbanu Bibi at village Borkolia, Naskara, by common house number so voter list of 1985. Paragraph 10. That after long period of eroded area of village Talakura created a new job, that is office birthplace. Then OP, including all the family members, shifted his residential house from Borkolia, Naskara to his birthplace, that is Talakura, and started residing there by constructing dwelling house without any information to the police.
And consequently, and
concerned authority. Their names in the voter list of Chalakuta. GP hence the voter list of 1997. Office name has been chose as a T voter at village Borkolia, Naskara under 22 South Salmara. Annexer, the voter list of 1997. Thereafter, the office and his family's members inserted their names in the voter list of 2006 village Talakota. Office name including his other family members' name included in the different voter list of Talakota GP. Kopi and his other family members is regular voters of village Talakota. They got elector photo identity card and the Kopi got PAN card right number also like Amjad Ali Sheikh, son of Ibrahim. Next, the printed copy of voter list of Annex 10 is the printed copy of voter list of 2015. Annex 11 is the printed copy of voter list 2017. Annex 12 is the electoral identity card 2013.
So basically you have this document of NRC of 1951 having your grandfather Khudu Sarkar, Rohim Box, your father, and Golezan Nasa, your stepmother. That is 1951 NRC. In the first voter, then you have given a land document of 1962 where your father's name appears. You have given voter list of 66 of your father and mother. Correct? Chandrabhan is your mother. Then 70, father and mother again. 77, mother and you. Correct?
Yeah. Mother and tradition.
When did your father pass away? When did your father expire?
73.
Only Rohim Box.
Where have you stated?
Paragraph 8. Case 5.
No, in your written statement.
Here. Cross examination, my lord, he has stated.
Hmm?
From in the written statement, he said that in others right. My lord,
Written statement, you did not state anything when he died.
written statement, my lord, it is not clear. One is, but in cross examination of PW1, you see that was cross examination also made by the my lord learned member. Yes, cross examined the petition. The evidence is 65. Strictly cross examination. 65. Nobody to cross examined by the tribunal at page 56 is the type code in Miller and 57 is the handwritten here. But I am reading the type code. 56, page 56. My father died after 1970. First line.
Page?
Page 56, 57. More Devta Metro 1970 son of Bishop. Page 57. This is the process designed by the number 8. More Dharma Salagura, Yalmarit Gaon. Grandfather naam Kudu Sheikh, Aro grandmother naam House. More naam Salagura, Mar naam Chandraban, Aru, Patiyar naam Gulajar. Saribhai. Now. Abdul Jabbar Sheikh, Ibrahim Box Sheikh, Gopar bin Sheikh. Actively and please, yeah. So in the cross examination, my lord, here is key.
About the death of his father.
Including my lord, both of the. I had last year wrote first time in 1977. I was married before 1985 and casted vote with my wife for one vote. There is no case in our family. Due to erosion of soil by river, we went to the village Naswar. Thereafter came to village Shialmari. And I have 5 children, Shohar Ali, Mohor, Tumeta, Ujit Ali, Anjuara Khatun. I have landed property at village Shialmari. This is the cost activity. Whatever he stated in the written statement as well as the evidence, it's also reflected in the cross examination also. And in the evidence, my lord,
How these evidence materials were dealt with by the learned tribunal?
Was his Hussein, he was not minority, he is not.
Who's DW2?
DW, the cousin brother of the petition. Akhtar Hussain, Elias Akhtar Hussain.
Cousin of the petitioner.
Page 15.
And DW1 is the petitioner. Two witnesses.
DW3 is also there. He hears from the final program. He brought it. It is not exclusion. Program is not exclusion. It's brought by college.
Who proved Khotian? DW?
DW3.
Who is he?
Is the office settlement office. Occupation of office assistant settlement. Occupation is office assistant of settlement office Dhubri. Page 66, 67. Page 66, on the type copy. I appear today and bring the final Khotian of village Chalagura Part 1 with me from office. On the said final Khotian book, the name of Roy Box, son of late Kudus Sarkar, registered at Khotian number 12. On 19/9/1962, registered the name of Roy Box on the said Khotian book. Exhibit 2 was issued from our office. Where head assistant S. Koju signed and I know his signature. Original Khotian book is completely safe and exhibited. From the WS evidence and the evidence of the DW2 and 3, it is clear, my lord, that the petitioner from the grandfather to the mother petitioner, he has a legal resident of Samayat. He is born and brought up in Assam at the village Chalagura. So he is a citizen of India by birth. But the landed court will, tribunal below, my lord, by examining the age in the voter list and they found some anomalies in the age of his mother and the petitioner, so come to that he is not proved linkage with his father, and his father is a projected father. That is the version of the findings of the land of tribunal.
The age anomaly,
petitioner-
age anomalies were held to be fatal. The age anomalies were held to be
Yes,
fatal
age anomaly is that factor is
by the tribunal.
and the linkage is not. These are the two, basically 2 points. Whether linkage is proved or not, I don't know.
Linkage always has to be proved.
And the age anomaly, nothing else. And my lord, moreover, in the judgment, my lord, the evidence of DW2, my lord, that is not a discussion, my lord, no reasons has been given, not considered, my lord, in the judgment. Evidence of DW2. And since, my lord, not a member has cross-examined the petitioner as well as the DW2 also. My lord, it is, my lord, I say that, my lord, this is not the fair trial. Okay, my lord, he has acted as a judge as well as the prosecution also. That's why, my lord, it also, this opinion is very liable to be satisfied. In this regard, my lord, I make to submit some citations.
How many your father had, no, you have how many siblings? Brothers, sisters? Who are your brothers? Please give the names.
My lord, there are 3, page 44. Last 4, my lord, last 4th line, 4 lines. Opposite party were 5 brothers and 2 sisters. Their names were Ansar Ali Sheikh, this is Jamshed Sheikh, this is Shamsher Ali Sheikh, this is Amjad Ali Sheikh, Bobi, Moshiran Bibi, Munna. So these are the brothers and sisters.
You come to page 19, the NRC copy.
Right.
1951. Serial number 4 is what?
Page number
19.
9, yes.
Serial number 4,
Serial number Shamsher Ali Sheikh.
son of Rahim is your father. Your father.
Here is the Jamshed Sheikh. Here it is Jamshed Ali Sheikh. Like the Jamshed Ali Sheikh and Jamshed Sheikh. Person. J-O and here is J-A.
It is okay then. Serial number 5.
Serial number 5, Ansar Ali Sheikh. Ansar Ali Sheikh is the son of Sohail Box. Ansar Ali serial number 1 inquiry of bill.
Village to Gate. Chalakura. Hmm? Page, page 70. The learned tribunal found that the learned tribunal held in its opinion that the in para 3 of the judgment, page 71, that one of your brother Ansar Ali Sheikh and biological mother Chandravan Bibi age is the same. Ansar Ali is the biological stepmother. Then it will be then it can be biological brother. It won't be possible. Step brother. Your village is, what is your village? Borkolia, Naksara, or Shialmari?
Kalmari, they are from in the cross examination, it is clear. My lord, that another member has cross examined and give reply. Then my village is Talakura Shialmari. Sometimes Shialmari also. Commonly, my lord, it is told sometimes it is Shialmari. And actually it is Chalakura. So in the cross examination, it is clarified. The member has to examine. It come from the mouth of the petition. There. Yes. Either the two.
Alternative names of the same place, same village. That's what he's saying.
What? Cross examination on what?
Salakura.
Last line, my lord, in the cross examination, I have landed property at village. Shialmari Chalak. Or India might have sometimes eroded here, sometimes created another.
That is a really.
Yes, Mr. Pang. Anything else, Mister? Regarding?
Regarding cross examination by the tribunal as well as my lord, not evidence not considered by the tribunal. My lord, some petitions are there and regarding discrepancy of age, my lord, appearance is the Abdul Rahim Ali, alias Abdul Rahim, and Motiur Ram. My lord, I have given the list of the cited.
Yes.
Along with the paragraphs, my. In the, my lord, Shakina Khatun versus Union of India, my lord. In paragraph 15 and 16. Paragraph 15. Regarding cross examination by the private. During our attention to another aspect of the properties contracted by the land at private, we are waiting to see that the cross examination of all the witnesses were conducted. We have done for the order sheet. Then with the relevant, states the relevant dates. Dated 10/4/17, cross examination of BW 1, 29/8 to 17, cross examination 16/1/17, cross examination of BW 4, 24/1, cross examination of BW 8. The presence of the government leader assisting government bid is not disclosed in the state. The impugn order dated 26/8/17 records the presence of the petition in very similar circumstances, subordinate banks of the court. By order dated 25/3/25, WPC numbers held as the only possible view would be that the London tribunal had embarked on the first examination of the database and that thus had impermissible as the person registered having given our anxious attention to the conducted by the tribunal, we are left with no option but to hold that the proceedings in case number suffers from procedural illegalities and the manner in which the proceedings were conducted do not inspire the confidence of the court that the proceeding to have a fair and impartial adjudication by the land tribunal. In such view of the matters, the present rate petition is excused by setting aside the order dated 13/6/2017, which had allowed amendments to the US and the evidence of sick DW1 and also set aside the opinion letter.
This is recently decided 26/8. 26/8/25.
Yes. Yes, Raja, in this case also, madam, fair use state. Regarding non-consideration of evidence of DW2. Paragraph 4.
It was second I found the second only sir. What's the next second it? Johora to what is the next person? Good also. You don't need to. Rosnar Begum. Get us. Which one? You can try go. I like this. You have given one copy of Johura. Do you have another copy? No. You know?
Oh, yes.
What's it? Yes, it's there.
Middle, my lord, it is also said that middle portion of paragraph 4. It is also said that the landed tribunal had failed to disturb the evidence of OPW 2 and 3, and it is also failed to discuss anything in respect of the answers given by the OPW1 and OPW2 to the queries by the land tribunal. In the considered opinion of this court, the power of the landed tribunal to put queries to the witnesses is related to the provisions of section 165 of the Evidence Act 1870, which forms an integral part of the evidence of fact. On perusal of the order sheet of the landed tribunal is seen that by an order passed by the Honorable Court in WBC number so and so, which was transmitted under memo number so and so, the landed tribunal had heard the case and pressure from the stage of airport. While rendering the opinion, the landed tribunal duty had been cast upon the landed tribunal to give finding on considering the evidence on record, including the queries made by the learned tribunal to the witness. Hence, this court is of the considered opinion that the non-consideration of the evidence available on record has caused prejudice to the prosecutor. If the learned tribunal was of the view that the evidence on record is not relevant, a finding to that effect ought to have been recorded, which in the present case is missing. Under such circumstances, we are inclined to interfere with the impugned opinion, which is hereby set aside. The learned tribunal is directed to pass the opinion fresh in the light of the observations made here. Question number 6, question number 11. Paragraph 7, 6, 7, 8. In view of submission made, we have gone through the opinion of the tribunal. From the opinion.
Mr. Day, these are principles which are general in nature, that all evidence have to be taken into consideration. Relevant evidence, relevant materials have to be taken into consideration. So on your case, on the facts of your case, what is your submission? Why is the opinion dated 5/11/2019 not sustainable, unsustainable in law? Why?
The non-consideration of evidence of legal issue is bad in law, and as such, the impugned order is liable to serve.
DW2 in support of his. Let us see DW2. He is your cousin, isn't he? Cousin. Where is his evidence?
DW2. That was not also considered because his evidence is all not considered. Not disturbed. And considered. And if he DW2 evidence of DW2. He has exhibited some documents himself. And thereafter, supported the documents of the exhibited by Providence DW1. Almost my lord as DW1. And in cross-examination also here. Supported. for a list of 1970. Yes. Supported the exhibited documents of DW1. And moreover, he has exhibited 1970 voter list. Stated in paragraph 3.
Was this 1970 voter list mentioned in the WS?
It is not mentioned in the document. It is mentioned in the evidence of DW2. It is support in support of.
Oh, let us see the WS. Anything did he say about his cousin? Did he say anything about his cousin, DW3? No, cousin. No. Has he said anything in the written statement about DW3?
Is the cousin's name also there. Cousin's name is mentioned. Father's brother. Because it is the son of late Jabbar Ali Sheikh.
See, this
In the documents he has stated.
DW3 is one after Hussein.
DW3 is the after.
Where is after Hussein mentioned in the W? Yes.
DW2 is the after Hussein.
Huh?
After Hussein.
Is DW2?
DW
Sorry, yes, DW2. Where is the DW2 mentioned in the written statement?
whose father's name is there. Because here they stated my father has 4 brothers. So like this in the WS. There are 3 of the WS.
He's said to be the son of Jamsher Ali Sheikh. Right?
Jabbar Ali.
Jabbar Ali Sheikh.
Jabbar Ali.
Jabbar Ali Sheikh. And so,
Son of
Abdul Jabbar.
late Jabbar Ali Sheikh. Where is Jabbar Ali Sheikh? Oh, how is Jabbar Ali Sheikh and Jabbar Ali Sheikh same person?
different names.
Firstly,
Is the evidence here?
whose evidence?
DW2.
DW2 will come later. First, we'll have to see the written statement, pleadings. He has not mentioned the name of this after Hussein. You say after Hussein is the son of one of the cousin, whose name is also cousin, but Jabbar.
His father is Abdul Jabbar. Jabbar Sheikh. So it is legal Jabbar Ali Sheikh. Abdul Jabbar, my lord, is written in the paragraph 3 in the by DW1.
But DW2 himself, he says that he's the son of late Jabbar Ali Sheikh.
Jabbar. Here is also Jabbar Sheikh. Abdul Jabbar Sheikh. Ali Sheikh, here Jabbar
These are
Sheikh.
two different names.
Abdul Jabbar Sheikh is my father. In his statement also. DW2, my lord, kindly say. And paragraph 1, last 5 lines, my lord, middle, my father were 4 brothers. Abdul Jabbar Sheikh, my father. Rohit Baksha, Opi's father.
Mr. Day, sorry to point it out, but see page 50 and page 58. Page 50 and page 58. And 58. Page 50 is DW1 and 58 is all the same. You have just copied same evidence.
Considered That has not been done by the tribunal.
No, first, whether DW, he is not an official witness, he is a relative. His relative's name has been uttered in the written statement. Answer is no.
But his
No, no, that is not the question. Then you can say his grandfather's name has been uttered. Why not somebody else? No, isn't it not required that his name should have been mentioned in the written statement? From where he has come? Then you can keep on extending. His son, his grandson.
Any document to show the?
his father has four
No, if you know that he is one of the persons who would be supporting you, wasn't it your duty to name him? He is not an official witness. Relative. So isn't it required to mention his name in the written statement?
The same he has stated, the family is the same names he uttered. So, my lord, another view, my lord, in this case, is not possible because chronologically, if your lordship gone through, then all the family trees are similar.
The chief.
Right.
We say that WS cannot be hampered.
Of course. The DW2's name has also come in the documents. You are a relative, he said.
He has stated, submitted two documents, my lord, exhibit X,
Page.
page 59, it is evidence, my lord, he has exhibit.
Yeah.
My election photo identity card.
50?
That is pro.
No, a document along with the petitioner.
That
No connection with the petitioner by document. No, so far as his identity is concerned, photo identity card, EPIC, those are okay. But any document where his name and the petitioner's name are found in common.
that is really, I have not collected the voter list of this family. His father, another family, voter list, maybe they are, my lord, but whichever relevant to my case, my lord, I have from grandfather, father, mothers.
No,
That
you
portion, my lord, I have.
have been saying that DW2 is your cousin. and is supporting your case, supporting by oral statement and also by documents. What is the documents which has been brought on record to show that DW2 and petitioner are connected?
Statement, evidence, and cross-examination. Admiral has himself cross-examined him, so my lord, it has some authentic value. The tribunal has cross-examined him on the evidence filed before the tribunal. So my lord, the London judge, the London tribunal has to consider that aspect of the matter. It is not, he was not cross-examined, he, the London member himself cross-examined him.
Oral evidence would be enough.
But if it is cross-examined, this should be admitted, my lord, and because other side, my lord, denial, not more denial. Because the member himself, my lord, cross-examined, and
You are equating this to be a normal civil dispute.
also there is citation.
You are equating this to be a normal civil dispute. This is not a civil dispute. Cross-examination is not there, so admission, the evidence would be admitted. Which one?
Because it is once the tribunal is not in the mind, then his evidentiary value is there, man. You don't be extraneous.
We have read Johura. That's on a different context. What is to be considered, what is not to be considered. But what is an admissible and acceptable piece of evidence, which would have a bearing in the decision-making process? And what did DW3 do?
DW3 is the, my lord.
Office assistant, what did he prove? What did he prove? What did he prove?
He has proved the final question. Where the petitioner's grandfather, father's name reflected the final question of 1962.
Okay. That's all?
Eight, my lord. Kohimali, page 40, paragraph 41 and 42.
Discrepancy of age, you have relied upon Rahim Ali and Mutiur Rahman. Okay. Mr. Payang, have you, this list has been furnished to you? Please give a copy of the citations. Because we'll like to have your response in these citations also.
Minister, my lord, if your lordship may kindly see the WS at page 44, my lord,
Page
44.
44.
Yes. What his description is, my lord. There are trees, the, my lord. The above noted case has been registered against the opposite party, that is Bastless. Para 3 may be seen, my lord.
Yes.
That OP party is a genuine citizen of India by birth. As born and brought up in village Salakura, opposite, that is by birth. My lord, no date of birth, no year is mentioned. When he is born, at least the year or probable year, my lord. Brought up at the village Salakura. Opposite party's father, forefather also born and brought up in the same village, that is Salakura. Grandfather name is, this is Kudu Sheikh, and grandmother, grandfather name is Kudu Sheikh, mother. And grandmother's name is Hausi Bibi. Both are died before the born of OP. This all are vague statement. OP party's father was 4 brothers, namely Abdul Jabbar Sheikh. This is one. Rahim Box, alias Baksa, Asiruddin Sheikh, and Ghaffar Ali Sheikh. OP's mother name is Sandra Bibi. Sandra Bhan. They are all died. OP party, opposite party were 5 brothers and 2 sisters, namely so-and-so, one Ansar Ali Sheikh is deceased, Jamsher Ali Sheikh deceased, Shamsher Ali Sheikh deceased, Amjad Ali Sheikh, OP, Basiran Bibi, Tasiran Bibi, and Mano. Opposite party's wife name is so-and-so. That part is not important. Now, if your lordship can you see, this is exactly same as the evidence. Evidence in SIF of PW1, page 50 mile. Your lordship has seen. Now, if we cannot presume, my lord, as per this record, OP has 4 brothers. Number 1 is, my lord, Ansar Ali Sheikh, who died. Jamsher Sheikh died. Shamsher Ali Sheikh died. Then the petitioner. If we see the, my lord, voter list of 1970, my lord.
1970,
Page 26.
Page 27.
Yes, 27 is the vernacular. Here it is said, Sandraban Bibi is the mother. She is about 29 years. And Ansar Ali Sheikh is 29 years. The brother whom he has mentioned at my lord, page 44 as well as 50. Now, at this stage, they were not in the cross-examination. At this stage, and in the High Court, they are saying that this Ansar Ali Sheikh is my lord, no, is stepmother's son, stepbrother. This was never a, my lord, case in the tribunal. No, stepbrother. He is saying he is his stepbrother. This Ansar Ali Sheikh. But in WS, neither in the WS nor in the evidence, he has said that they are his stepbrother. He has categorically stated he has 4 brothers, 3 brothers, 3 sisters. Brothers are so and so, so and so, so and so. Even in the first tense, my lord, if your lordship may see, in the first para 3, he has not stated he has any stepmother. But in the last part, this has been corrected later on in the page 45 that he has one stepmother. So and so, so and so. But this is corrected later. Same thing is there in evidence also. Had it been corrected in the very first day itself, my lord, it's a natural. That I thought it's my lord understanding. Had it been corrected in
Where is the mention of stepmother?
page 45, my lord.
Oh, handwritten.
Handwritten. This is corrected, handwritten. Whether there was permission or not, I don't know, my lord. Whether the WS can be corrected in that way. Because if your lordship may see the evidence, even evidence also they did not in the first they did not disclose this thing. In the evidence also they corrected in my lord page 51 in the same manner. Page 51. In the same manner. That means these were not inserted.
Evidence, yeah,
Page 51. Evidence was filed later on. After filing of the WS only. At least in the evidence, they should have given the correct person. But this was not correct. This was also corrected later. Now, the mother person is corrected.
Just a minute. Let's go through. See, the written statement was presented on 27/12/18.
Yes, my lord.
Assuming that he had corrected within the permission of the court. But the evidence was filed on 2/3/19.
Yes, my lord. At least that's why I'm saying.
5 months.
5 months, they could have included it properly.
That means till 2/3/19, the written statement was also not correct.
Not correct. Same date. It might have
But
been
cannot be
corrected.
before 2/3/19.
Yes, cannot be before 2/3/19.
I will answer, my lord. I will reply, my lord.
So, what my submission is, my lord, this could correct somehow, but the other part that the Ansar Ali Sheikh his stepbrother, that he could not correct it. In fact, my submission is this was not even in the cross-examination also. Anywhere they did not disclose this thing, that this Ansar Ali Sheikh is my lord stepbrother. If that is so, the tribunal cannot presume, my lord, that he is his stepbrother unless and until he explains all these things. That's why on the very face of the record, my lord, if we see page 27, this Ansar Ali Sheikh and mother is of 29 years, same years. Both over there, 29 years in 1970. In 1970, both over of 29 years.
No, I think on this he had submitted that he is the progeny of the stepmother,
No,
not
that
the
is
biological mother.
that is for the 1966, but
You
that is for the
submitted- did you say
1966 because 1966,
the
madam,
same age, this question had raised, no, same age
Same
of
is,
the
my lord.
mother.
That is, in the opinion itself, it is clearly written, my lord, page 69.
Not the biological mother
Last two lines, my lord.
of the
landed-
stepmother.
One landed friend has submitted entirely against the record, my lord. It is that it is subsequently added. It is added with the permission of the court, and the court has reflected this, my lord. That the Gulajan Bibi is the stepmother of the petitioner. The last two lines, my lord. The father's name is Subaksha, so and so, mother's name is Chandravan Bibi, and the stepmother's name is Gulajan Vinasa. So it is clear, my lord, in the judge opinion itself.
I'm
It
not
is not
saying,
manipulated later on, my lord.
I'm not saying,
Whatever submitted, it is with the due permission of the court. Maybe, or may not be also, because it may be corrected earlier also.
Cannot be corrected earlier.
My lord, I do not know.
No, cannot be.
And it is
That's the-
subsequently also.
If it was corrected earlier, if it was corrected
my lord,
earlier,
Then it.
Mr.
with the
Mr. Day.
permission of the court and the.
No, no, we are
tribunal
not,
has-
we are not saying that it is not with the permission. Let us assume it is with the permission. But it could not have been corrected before 2/3/19. Because 2/3/19 you had presented the chief examination with the same mistake. Come to page 51.
Permission, I don't know, my lord.
Now let us assume it is his permission. But these are afterthoughts.
It may not after, because it
Till-
is
till
it
pa-
is reflected in the opinion, my lord.
Opinion has reflected, we are not
Yes.
saying, but
So it was within the knowledge of the tribunal.
it has to be. We are not saying it is inserted after of the opinion. It is
Why
before
is
the
the date,
opinion.
my lord, it is, there's no
Date of filing 2/3/19, the
27/12/18, my lord.
no, that is the written statement.
Written statement, yes,
Find the, come to the evidence in chief, page
Evidence.
50.
yes.
2/3/19. Come to the second page, 51. Same thing, handwritten.
Well, same person has written.
Handwritten, when did you write this? Can you write it before 2/3/19?
Evidence cannot be corrected before.
No, even if you
2/3/19.
correct,
On that,
it has to be corrected on, not before 2/3/19.
as far as the evidence is concerned, that's what.
You have presented it on 2/3/19 with a handwritten thing. At best, it has been done in 2/3/19, it cannot be before that.
My lord, maybe with due permit, because it is within the knowledge of the tribunal member. And it is reflected in the opinion, my lord.
That is true. I'm not saying it is not reflected, my lord.
It is reflected in.
It is reflected, definitely it is reflected, it is corrected.
Subsequently, it was
No.
not at all
After,
material, my lord.
it may be up. Definitely before the opinion is passed.
Just a minute. There is no order that any permission was given to correct.
No, but it is reflected in the opinion, my lord.
Obviously, it is reflected. Whatever is there in the opinion, we cannot say it is not there.
My lord.
We have seen the, we have.
So, my lord, can it be questioned now, my lord, before this honorable court? Whatever done, it should be raised before the tribunal.
We have seen the orders. There is no order allowing, directing or permitting
lord,
you to make.
I am
correction.
of the, we have the subsequently corrected. Which court this has to raise? Before the high court or before the tribunal? This objection, if any, my lord, regarding evidence or WS, correction or manipulation, whatever it may be. I do not know. To whom it is complained.
You saying you not know will not do. You are the petitioner.
I am the.
And you are before a court of equity. Cannot,
My
you
lord-
cannot make those kind of submissions.
My lord, my.
If you do not come with clean hands in the writ
No,
court,
my lord.
we are not even going to examine
All
your
the-
case.
The things are the record, my
We
lord.
are not even going to examine your case if you find your conduct is not bona fide. And you are answering that this was not raised. Who is before this court?
My lord, these are all matter of facts, my lord.
That is what we are trying
These are
to.
all matter of facts and the.
We
Court-
are examining all
Court
the
record
orders.
is before your lordship, man. Your
There is not
lordship
even a
has
single
to,
order permitting
lordship
you.
has to verify from the record.
That
Whether
is what
it
we are
is,
doing.
how my learned friend come now that they say that it is.
There is no order permitting you. to do that.
manipulated.
Let us see that portion of the judgment or opinion.
Within the,
where it has
within the
been
knowledge of
discussed.
the tribunal, my lord.
My lord, as your lordship has pointed out, the 1970, the report was called. The report, if your lordship can kindly see page 72 onwards, 72 first part, 71 last part, my lord.
Now let us clear this first. Mr. Day has raised a very pertinent question. Let us clear this first. First things first. We are seeing the order sheet. Which date the written statement was presented?
Written statement was presented on 27/12/2018, my lord.
27?
12/2018.
OP present and files written WS along with documents
My lord, one thing. my lord,
and
that-
certificates. Member on CL, fixed 9/1/19 for hearing. OP absent, advocate files petition for time showing ground. So and so fixed for hearing. That is in 291. 1/2/19, OP present files petition so and so for time showing ground. Fixed 18/2 for hearing. 18/2, OP present and files petition showing time, showing ground for time. Fixed 2/3/19. 2/3/19, OP
Yes.
present and files evidence in chief along with documents and certificates and files petition for time showing ground. Thereafter, there is not even a single order allowing him to correct written statement. Let us be clear on facts, on the orders. You cannot go by emotions like this. Prospering ground. Arguments heard from both the sides, so and so forth. There's no order.
If we read the my lord, entire para in entirety, para one of the evidence,
Page,
my lord, the para one of the evidence, page 50, my lord, as well as para 3 of the WS, my lord, same thing,
page 53.
page 50. my lord.
550, yes.
50. In entirety, my lord, it says, I am a genuine citizen of India by birth, same thing. I was born and brought up at so and so. My grandfather's name is so and so, Kudu Sikh. Grandmother's name is so and so. Both are died before my birth. My father were 4 brothers, so and so, so and so, so and so. We are 5 brothers, my lord. Sikh. My mother name is Chandravanu. They all are died. So this is clear. This is categorical statement. My mother name is Chandravanu. There is no
So the
whisper about.
father,
Yes,
father, 4 brothers, and mother, they have all died.
died.
Okay,
We are brothers,
5 brothers.
5 brothers, 2 sisters. Even 5 brothers. Here he has say, Ansar Ali Sikh, Jamsher Ali Sikh, Jamsher Sikh, Jamsher Sikh, Amjad Ali Sikh. The 5th one is not mentioned. Basiran Bibi, Tasiran Bibi, Monnaf probably, Monnaf. Now, my lord, my wife's name is so and so, brother's name is so and so. Everything is there. Only after the completion of the entire paragraph. Now this OP have 2 mothers. Now it become OP has 2 mothers. It's contradictory to the first part of the same. OP has 2 mothers. That is Gulzar Nisa, stepmother, Saran Banu.
Sorry to interrupt you. Page number?
Page
50.
50. It's contradictory to the first part of the statement.
Yes, got it.
Father had 4 brothers. 4 brothers. Mother Chandrakhan. They all died.
Now,
So and so. OP has 2 mothers.
lastly,
Chandrakhan.
they have,
Chandrakhan has been mentioned twice.
yes, twice.
It is not the thing that
Yes,
I have a stepmother also.
yes. That could have been started in the first line itself. Also. Now, second thing, my lord, in the same para, suppose the another thing which they are developing in the High Court, this was not there pleaded. My lord, the Amjad Ali Sikh, whom he is saying that he is brother, he has nowhere stated that he is his stepbrother. Nowhere. Now, Amjad Ali Sikh, whom my lord, on the basis of which the in fact the entire case depends. My lord, the
Who is Amjad Ali Sheikh?
Amjad Ali Sheikh is projected to be his brother.
DW2.
No,
No.
He is Akhtar.
No. He is Amjad Ali Sheikh. If your lordship may kindly see page 27. Ansar Ali Sheikh, sorry, madam. Ansar Ali Sheikh. Ansar Ali Sheikh.
Yes. Answer Ali is his uncle.
No, brother, my lord.
No, no.
Brother.
Okay, his brother, correct.
Answer Ali Sheikh.
Correct, brother.
Yes, Answer Ali Sheikh is brother, my lord.
Yes.
Now, can the brother and mother be of same age? That was the issue. Because in page 27, Chandraban Bibi and Ansar Ali is the same, is of the same age. Now, if it is not disclosed that he is my stepbrother, the tribunal cannot presume that he is his stepbrother. Your lordship was querying another aspect, my lord, the election officer came. Election officer, they sought for a report from the election office. Election office has not said that aspect. What election office has said in page 71, last part, my lord. Election office said it is correct. That means the age is correct there. This copy is correct. It's saying certified copy of voter list of 6670, which the petitioner is saying 7785, 2000 are submitted by OP are genuine. The report also disclosed that due to their oversight voter list 1963, name of Kundu Sheikh only, madam. Name of Kundu Sarkar and serial number are wrongly written in the certified copy, not the age. After perusing the report, enclosed printed copy of the 1966-70 serial number with page numbers are found different. That is another aspect, my lord, the serial numbers and page numbers are not found daily. In report, enclosed printed copy of the voter list of 66, the first page of serial number 86 and back page without page number, serial number begin from 91. Same as in the voter list of 1970, first page is serial number 90 and in the back page, next page without marking page number begin from serial number 191. So that's why this were not accepted. Even then, my lord, if we say that report was correct, report has not said this 1970, in 1970 voter list, the age is wrongly mentioned. It is correct. They are saying that this is genuine. There is no wrong in this document of 1970. Now, if Chandraban Bibi, Ansar Ali Sheikh and the petitioner is a brother, Chandraban Bibi cannot be mother of the petitioner. That's why my tribunal has not, tribunal has discarded the entire. And this is not a pleaded case there in the tribunal.
What is the date of birth of the petitioner, Mr. Dev? Or year of birth?
He is aged, my lord.
No, we know, we know his age. What would be his year of birth?
Nineteen 51, 52, maybe, my lord.
51.
As he stated his age only, my lord, date of birth he has not stated.
Not 51, cannot be 51.
45, madam.
Huh?
It should be 45.
1945,
Yes.
petitioner.
Yes.
55, my lord.
Amjad Ali Sheikh. Amjad Ali.
Amjad Ali.
Yes. As page 50, my lord. This is the affidavit shown by him, where he said that he was 64 years in 2019.
Yes.
Yes.
64.
64. 2019 minus 64, it would be 1945.
1954, 2000.
Yeah, 1955, sorry.
55.
1955.
Yes.
Where is your voter list, Mr. Amjad Ali? 1977.
77,
Okay, you are 25 years old.
25. If 97 is 70, 25.
For the first time.
If this voter list is correct, his date of birth was 1952, my lord, something.
And here also some discrepancy with his mother. He
Yes.
says that age is,
Yes,
some
age
error
is-
is there, 64, 30, 25 and 35.
35.
10-year-old,
10 years,
10
10
year
year difference.
difference.
10 years difference. And if it is on 52, my lord, date of birth, the name of the mother, Chandravan Bewa, BB, whatever it may be, my lord, Bewa. Her name should have been there in the, my lord, the NRC 1951. Her name is not there in page 20.
Again,
51 or 56 motion, 51 of it. What did person's name in page 20, my lord? Kudu Sarkar, it is not Kudu Sikh, another spec, it is Kudu Sarkar, Sattar Sikh, Samarjan Sikh, Ramsiralis. So these aspects are there, my lord. The murder is not there in 1951 NRC. This was prepared in 1951. And the petitioner, if we accept this voter list of 1977 as genuine, my lord, the petitioner would be born in 1952. Then the petitioner, the mother of the petitioner and the father would have been in the same list in 1951. It's not there. And other brothers are there in 1950. And another aspect, as your lordship had rightly.
But Mr. Rank, if you take page 29 as a standalone document,
Yes,
here is a person who is aged 25 years and his name is enrolled in the voter list of 1977.
yes. That is true. His name is enlisted in 1977. My lord, the thing is that we are not in we have to find it out before 71 or
Correct,
link to a
correct,
person before
correct.
71.
Now, whether the question which will arise, whether his name has been inserted just like that, or he is the son of Rahimuddin, and there is a linkage.
That is it.
There's linkage has to be proved.
Yes, my lord, that is the point, my lord. Because the person, my lord, even in Supreme Court, let us in the Supreme Court, it is the question of NRC. When NRC came, my lord, the issue came up. If one of the brother is declared Indian, one of the brother is declared foreigner, what will be the situation? Because they claims that my brother is declared Indian, so how can I be declared foreigner?
Correct.
In that case, Supreme Court has said, my lord, that one brother may come immediately after 24th of March 1971. So he will be automatically declared foreigner. So that aspect that he came prior to 1971, that has to be proved. Even two brothers also. It is a case of two brothers, own brothers also. That this my lord Amjad Ali, he is in India, he entered into India prior to 71, or he born in India prior to 71, that has to be proved. Because my lord, he may come just prior to 1985 and approach this someone else that my name may be recorded. In my lord, electoral rule, generally it can be recorded by any means. There was no hard and fast rule at that time. So my name may be recorded and he may adopt someone as his father or mother. What will be the situation then, man? So it is, that's why, my lord, the burden is on the petitioner to prove that I came prior to 71, or my date of birth is I born in India prior to 1971. Nobody can say except the petitioner, my lord. That's why the burden is shifted to them, not to the state. If this person come just prior to 1985, he entered in this name of voter list, nobody can, my lord, find out. So in that case, we have to see, my lord, enter facts. That's why, my lord, I'm saying, if he is the biological son of Chandrapan Bewa, my lord, probably at the age of 10, it is on the basis of record, at the age of, my lord, 10 years difference between the father, mother and son. It's not, my lord, acceptable at all for a genuine, my lord, general person. If this is the only document, because, my lord, this 1977 voter is the basic document on the basis of which he is claiming, with Chandravan Bewa, who is the wife of Rahim Bos Sheikh. The age gate is very important, my lord, here, because he may come and adopt anyone. That cannot be said, my lord. And in this case, because, my lord, in the pleading, they have not taken he has a stepbrother or he has a step, my lord, later on, though it is pleaded, but clearly he has not said it, he has a stepbrothers, these are his stepbrothers. Secondly, the, my lord, the DW2, who came as cousin brother, his father name is not there in the WS, what your lordship has pointed out. Even his father name is not there. DW2, page 58, my lord, Akhtar Hussain, alias Akhtar Hussain.
His name is not.
His name is not there. Even his father name is not there as uncle of the petitioner in WS, my lord. If
No,
you,
it's there.
lords, Akhtar Hussain, alias, my lord, page 58, son of late Jabbar Ali Sheikh.
The word is there?
No,
Abdul Jabbar Sheikh.
Abdul Jabbar.
Abdul Jabbar Sheikh is, one Abdul Jabbar Sheikh is there. But Jabbar Ali Sheikh is not there. He has not given alias also. He has not given alias, my lord.
In the evidence, he has given evidence.
Yes.
But
No,
not
evidence DW2 has given,
DW2.
not DW2.
No,
DW2
DW2
was not said anything.
No, my lord, first statement. I, Akhtar Ali, alias Akhtar Ali, son of late Jabbar Ali Sheikh. This is clear. Aged about 66 years, resident of so-and-so. Now, this is copy paste. Other part is copy paste, my lord. He has not said that this Jabbar Ali Sheikh and Abdul Jabbar is same. Abdul Jabbar Sheikh is same in one person. He has not said.
He has given an alias in para, this number is wrong. Page 59. My father Abdul Jabbar Sheikh alias Jabbar Ali Sheikh,
Yes.
elder brother of OP's father.
Died. Yes. Named.
Please read the whole meaning.
Abdul Sheikh, Jabbar Ali Sheikh.
Died leaving his only 5 children.
Yes.
Akhtar Hussain alias Akhtar Ali. That is myself, Yusuf Ali, Muntaz Ali, Jahanuddin, Roham Ali. We all are alive.
So it clears, my lord, the intention, the, my lord, the bona fideness, because another aspect, para 3 of the evidence, my lord, this evidence, that my name has been recorded in the voter list of 1970 with my parents at village so-and-so, so-and-so, so-and-so. That is not correct. That is contradictory to his statement. And lastly, my lord, the tribunal has given opinion.
You can complete because before we complete, we're going to, before we are going to complete.
Yes.
Sir, Dave would like to reply something.
My lord.
Let him complete.
Yes,
complete
sir. I'll complete just. My lord, as I have read out paras, page 71 and 72.
Are you citing some judgments?
Yes, my lord, I'll,
I think then we'll have it continue tomorrow. Let us not do her because we like to
hear,
hear Mr. Day on his rejoinder.
yes, yes.
There are certain issues, some clarification be required. After the, before any disposal item, yours will be the first.
Yes.
After the motion or whatever is there. What is it?
Item of 32 to orders, my lord. But this may not be on 9th of December, my lord.
We'll see. Is there any urgency?
No, my lord, this is not, but I may not be there, my lord, sometime, my lord.
It will be listed. Don't worry. I think, the arguments have remained inconclusive. List for further consideration tomorrow. Rest, court master will give some dates. Then I can go. Polygon already. Tomorrow we'll take up. Mr.
Aku